This petition is dismissed. Abandoned. I take to mention the item for listing of it on 6th of Wednesday. What is the matter about? Standard. Is it new matter? Yes, yes. What is? Right, item number 11. Yes. What about it? I think your this amount is out of business. So let may be taken on witness. Huh? I think your this amount is out of business. Tell me one thing, is there any arbitration clause? Is there any arbitration clause in this matter? No. Are you sure? No. What is the amount? Amount received 89. And there's no agreement, contract agreement. Agreement received between the department and the. There's no thing. Okay, right. Third, Mr. M.Z. Shah. M.Z. Shah, learned counsel for the petitioner, who submits that the contract was terminated, who submits that the matter may be adjourned, as his senior is having some personal difficulty. Yes, anything?
May it please the court.
That have taken on witness. No, in this matter, I hear. Okay, right. List the matter on. Six. Tomorrow, what about tomorrow? Tomorrow, 6. Is it right? The matter pertains to termination of the contract given to the respondent number 7. The petitioner shall inform this court as to whether there is any arbitration clause in the contract agreement. 7. Listing of the case, my motion along my tomorrow. Notice is given on one day or two weeks on my stamp vendor. Eviction? It means stamp vendors are given license to up to June, but a notice, short notice is given 1 day, given to vacate this stamp vendor. So that is why Saturday is fine matter. Maybe come on tomorrow. Tomorrow is okay. But I pray for listing of a matter deputy can. We have filed it on Saturday, on 2nd. But can it be taken as a first matter regarding what? It's regarding matter sealing matter 5 4 wheels of the Vatsapara AC ticket. Tomorrow, what about tomorrow? Tomorrow is the date for sealing. We'll try. You can. If time is there. Can it be on Wednesday, madam? Huh? One more repetition. On new Wednesday, motion. Is it new? Yeah. On Wednesday. Thursday. Well, it's the tender same tender. Then we'll list it tomorrow then. Yes. May I please the question? Item number 23 to my lord. I am on behalf of Mr. Jail of the Council of the Petitioner. You are appearing for? On behalf of Jail of the Council of the Petitioner. He is suffering from illness. So I will take it up to water. Who is suffering from illness? Jail of the. So he's going to get well after 1 week. Is it? What is the matter about? I don't know, my lord. Right. Adjournment prayer has been made on behalf of Mr. J. Lasta. The issue relates to cancellation of the stamp vendor license. List the matter on Friday. Holiday? Okay, Monday. Public.
May it please your lordship. Lordship, I beg to mention item number 37 of the daily discount rate. Lordship, we have filed an affidavit today. Lordship, the matter is fixed at 10:15. Lordship, personal reference matter.
There.
I pray that the affidavit may be called for, Lordship. It may be taken up to that.
May I pray for listing of a vacating application, your lordship?
What?
Stay vacating application. Otherwise, your lordship, we have filed our reply related to that, your lordship. Proceedings are complete so far as I is concerned. On 13th, your lordship. Wednesday. More.
Yes, madam.
Please put it at
Okay.
deeply obliged.
With the question of the other side, my lord, I beg to mention item number 30 of the daily list, my lord. 30? Yes, my lord. In this case, my lord, respondent is filed an affidavit, my lord. Who need some time to file reply. One is time waiting. Wait. We'll see. Wait. We'll see. Yes. One matter was regarding non-payment of supply bill. There is a order for payment of interest. The interest is accruing, my lord. It has been settled, my lord. Amount has been already, my lord, to be released by day or today or my lord by tomorrow. Can it be on Wednesday? It can be closed. Some urgent. Only for closure. Okay. Tomorrow? This is tomorrow.
Lordship, I beg to mention for listing of an unlisted writ petition today.
Unlisted matter. It's a new writ petition.
Yes, Lord.
New writ petition.
Writ
What?
petition.
Regarding what?
Regarding Lordship tender relief.
Why today?
Lordship,
What has happened?
urgency, Lordship.
What is the urgency?
Lordship, while the tender of the petition was, petitioner was evaluated in
Was
technical bits, Lordship.
technical bit disqualified.
Yes, Lordship, disqualified.
Then?
But Lordship, today the financial bits will open.
So?
So there is an urgency, Lordship. We have filed, Lordship, already representation filed before authority, Lordship, on 26th.
No, you tell me what is wrong with the disqualification of your technical bit?
Lordship, but the petitioner is exempted from prior turnover and experience.
How? What is the turnover required? You see, madam, all these they can be subject to the outcome of the writ petition. When you ask for urgent matter, urgent listing, you've got to know the facts and the basis for the urgent listing. When you don't know the basis, then it's very difficult for us to give you your prayer. Yeah. So, and today we have got only two private secretaries. One is sick. One is child is sick. So we have tomorrow.
May I please, Lordship? Lordship, I beg to mention item number 27.
Yes. What about it, madam? What do you want?
Lordship, it's the arbitration petition. There is an arbitration clause is there.
You wait, madam. We'll see. We'll see. Wait.
Lordship, Engaged Council, today is, he is out of station.
No, out of station all the time cannot be. Just give me item 27. Let him come. We'll wait.
Please, Your Lordship, I beg to make a matter for listing for tomorrow. It's an urgent tender.
New matter.
Yes, Lordship. We fight it today.
Okay.
May I please, Lord? I beg to mention for listing, Lordship, a leftover matter. This was listed on 23 to 2024. But due to paucity of time, it was left over.
Pertaining to?
Matter direction has been sought from this court to dispose of the application submitted by the petitioner before the government authority. He has submitted the application, but they are not disposing the application. So day after tomorrow, Lordship.
Tomorrow.
Problems.
We will have prayer for Lordship, listing Lordship. Next week, any day.
Is it a new matter?
No, Lord, not for.
Huh?
For that.
No. What? You go to the registry. These are urgent matters that I can understand. Water matters, you go to the registry.
Yeah, please, Lordship. As per order dated mind of 6/11.
Okay, Mr.
T-Sheikh.
Third, Mr. T. Sheikh, counsel for the petitioner, who submits that the order dated 6/6/22 passed in WPC 4926 of 2019 has not been complied with. If to notice, returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by registered post with any within 3 days. This is the matter of the court.
May I please, Lordship?
Mr.
H. Buragani.
Mr. H. Bora Gohain, and counsel for the petitioner. Order dated 1/8/22, WPC 4280/17. Thank you.
Obliged.
No one appears for the petitioner on call. This is the matter after review.
Because the bed and breakfast,
Where is your approval?
my lord, the approval is pending, my lord.
Pending. So we wait.
As per-
Wait for some time.
Okay, sir.
Will issue notice.
No, my lord, let it stay at motion stage,
Why? Why?
because my lord has taken a view, provided my approval comes.
Correct.
Regarding the showcasing also, I have,
No, Mr. Counsel, unless your approval comes, you've got no case.
my lord, if it stays at motion stage, I can produce the approval, my lord.
You can produce it when it comes, when we, after we issue
Moment
notice.
for
No, we cannot clog up the, this motion column only because of waiting for your approval.
Admittedly, my lord, the GMC has admitted that they don't have any jurisdiction over it.
Where is that?
My lord, they,
Where is that?
on the last occasion, they admitted, my lord, that bed and breakfast facility doesn't fall under their
Correct,
jurisdiction. They don't have,
Correct. Then what to do when there's a lacuna?
my lord, in the interregnum, let me function. At
How
this
can,
stage, the
you see, Mr. Counsel, as per your own case, your bread and breakfast facility establishment has been allowed to function on the basis of approval given by the ministry.
Correct.
That period has expired.
That period has expired.
Then-
I applied before the last date. Now,
Mr. Counsel, unless the license is extended, you have got no right.
regarding that part, the guideline is silent. But the Tamil Nadu state, they have clarified regarding the interregnum period. I have submitted on the last.
Tamil Nadu state is a different state, Mr. Counsel.
Assam, there is no guideline.
There's no guideline. Then you're bound by the Union of India guidelines.
But since they are showcasing and subject to approval, the people who access
I understand.
can see my bed and breakfast facility in the Nidhi website, madam. That means they can call me up and
As soon as you get your approval, you come again. Then we'll think of passing out. So we cannot. In the meantime, let them file an affidavit. Who's appearing for the GMC?
as per and as per.
Okay, right. Heard Mr.
P. Bharadwaj.
P. Bharadwaj, Learner Counsel for the petition, who submit that the bread and breakfast establishment that has been established by the petitioner is still to receive the extension of the license provided to them by the Ministry of Tourism, Government of India. He submits that the GMC, on the other hand, do not have a provision for grant of a trade license for a bread and breakfast establishment. However, the GMC have asked the petitioner to close down his establishment on the ground that the petitioner does not have a trade license for homestay under the GMC Act, 1971. Issue notice returnable in 4 weeks. Mr. S. Bora accepts notice on behalf of all the respondents. This is the matter after 4 weeks to enable the GMC to file their affidavit.
Kindly issue notice on the interim also.
Notice is also issued on the interim prayer made by the petitioner. This is the matter of the court. Okay. Yes, two different names.
Two different name, my lord. Last occasion, my learned.
There was some judgment you had
Yes,
put
yes.
in here, then you would think, I was going to read it, yet probably taking it out again. It's not here.
Due to Lucas, my lord,
I have not taken.
paragraph.
Then how come it's missing? It was supposed to be here. I didn't read it.
Already,
I don't know now, you have brought out the judgment, he says that it is in his favor.
No, no.
Now,
Paragraph 15, my lord, only because of my lord, let them finish, my lord. Okay, my lord, I am the participating the tender process. That writ petition is not a participant in the tender process. So thereby is that due to locus that petition is dismissed. Paragraph 15, my lord, clearly stated.
no, I'm not on this issue. I'm on the issue of whether Nabak Kumar Das and Deba Das are the same person. That's-
There is a police report, my lord, please may kindly see.
Who took out the judgment from here?
I don't know, Lord.
It's not here.
I never know.
I was planning to read it.
Lordship, it was,
Where is the relevant
from
portion?
here, Lord.
Where is the relevant which paragraph is the relevant paragraph?
16, I think.
Paragraph?
15 and due to locus tender, my lord, this
Mr.
petition
Counsel,
is.
I'm not on that. I'm not on the locus of that case.
Well.
I'm on the issue of whether Nabak Kumar Das and then Deba Das are the same person.
13, para number 13, Lord. Lord, it is in my, it is noticed that the respective contention of the petitioner and the respondent number 6 have been given to rise to a number of disputed question of facts. So in a writ petition under Article 226 of the Constitution of India, the High Court has the jurisdiction to try issues both in fact and law, but such jurisdiction being discretionary and extraordinary has to be exercised only after consideration as to what facts are in dispute and what facts are not in dispute. Such a stage comes only after completion of the exchange of pleadings in the terms of affidavits among the parties in a writ petition in ordinarily decided under majority. In a writ petition, disputed question of facts arise requiring appreciation of evidence, both oral and documentary. And for determination of such disputed question of fact, examination of witnesses are found necessary. Then it may not be convenient to decide on such dispute in a proceedings under Article 226 of the Constitution of India. And in such a case, the court may decline to entertain the writ petition. It is settled that the High Court in jurisdiction under Article 226 of the Constitution of India does not generally enter upon a determination of question of fact which demand an elaborate examination of evidence to establish the rights to enforce which the writ is made. The present one is such a case which would require determination of several disputed question of facts of both oral and documentary evidence with examination of witnesses from the parties in a full-fledged trial. In such a view of the matter, the present petition is found to be not the proper and appropriate proceedings to determine such disputed question of facts.
I'm not on that. The question is whether that Nabak Kumar Das
Yes.
and Deba Das are the same person. Whether
Right.
this is that.
That part we are not, we as a AFDC Lordship, we don't know whether they are now, we are being placed documents that this is the documents, this version is, so we are not the
So
competent.
you are basically saying, since this is a disputed question of fact, they should go to civil court.
Yes, Lord. They should go to the civil court. They should go. Impersonation case should be registered, Lordship. That is not being registered till now. So we are not on that. We are not the competent authority. So if they are found wrong, if they have impersonation.
Right now you have given this fishery to whom?
This person,
To which person?
Nabo Kumar,
Don Navakumar.
Nabak Kumar Das. Yes, now
page 43.
We are not in favor of
Page
Navakumar
43,
also. No,
Page
no, Lordship.
43, my lord, 41 started, my lord. This is the Assam Fishery Development Commercial Limited, my lord. My lord, rule standard notice, my lord, turning to page 43. 43, my lord.
yes,
2.9 paragraph, my lord. If the bidder is defaulter to the foreperson, his or tender will never be considered for acceptance for any reason. Number next, 210. No member of a cooperative society will be able to submit tender personally on individual capacity. If it is proved that the bidder is a member of the cooperative society, his or tender will be rejected. He is a member of the cooperative society. And that case
he's
was
member of which cooperative society?
Fishery cooperative society.
This, where is the settlement order? Let us see the settlement order.
Settlement order, please may kindly see. Page 31, ma'am. Page 31.
So here, it has been given to him in his individual capacity.
Individual capacity. If the individual capacity also in setting matter.
Huh?
Because of he is a member of the defaulter cooperative society
As a Devodas.
as a Devoda.
At Devadas.
Devoda.
Their contention is that
Acha, actually, the Navadas is Devadas.
as per
Devodas.
their contention. I don't-
Contention as per record. I am going to on record.
So Devadas
Yes.
is a member of a society.
Society who is who was the defaulter.
Who was the default?
Yes.
Now, what is the name of that society?
Name the Kumotia Fishery Cooperative Society.
Where do you get that?
Page 47. Annexure 5 page 40. It's certified that Debodas, son of Horendas, so-and-so, so-and-so, Hemadi is a shareholder of Kumotia Group Fishery Cooperative Society Limited. His name at serial number 424 of the Bhutali. And phase-wise voter list page 48.
Huh?
My lord, there is a voter list, my lord, page 48, my lord.
Yes.
His name is 423, serial number 90, Devodas, son of Horen, in Bhebeli, my lord. It was issued by the Secretary Kumotia Group Fishery Cooperative Society, page 48, my lord.
Now, the only thing is, how do you prove that this Navakumar Das is Devadas?
My lord, initially, here all voter list and all are there in assembly voter list, his name is Devodas. And
Correct,
they are,
no?
yes, my lord, I am going to one by one.
Yes.
And this is now next 53, page for 53.
Very clear.
These are the village people. They stated that Novodas and Devodas is the same person, identical person, son of Horendas. Next, when you turn into page 57, Annexure 8. This was issued by the Gao Pradhan. Navakumar Das, Devakumar Das, son of Horendas, the same person.
50?
Next, my lord, your lordship, I'm going to one by one.
50, 50, 57.
57.
Who is this person?
It is, he is the Gao Pradhan of Lat Gao Bura, my lord. This is to certify that Gogamuk Rajastha, my lord. It is hereby certified that Navakumar Das, alias Devo Das, son of Horen Das, heavily Kubeto under Gogamuk Revenue Circle is the same and single identical person. I know him well. Next, my lord. Turn it to page voter list 1993. Annexure 9. The voter list of 130 Themaji LAC, polling station number so-and-so, polling station name so-and-so, in serial number 22, Devo Das, son of Horen. In particular is there, page 60. Page 29, my lord. Devo Das, Horen Das, father's name. Next, turn into page 61, voter list 2013. Voter 130 Dhemaji, Tidultal LAC, name of the locality so-and-so Bheveli. This is the voter list. His first, the father's name Horen Das. And next, his CL number 365, Devodas. That's number 5, as a Devodas. And next, his wife, Jimmy Das, wife of Devodas. And turn into page 63, 2014 voter list.
Yes, sir. 63, yes.
63, voter list 2014. 130 Dhemaji Sodoti LIC, name of the so-and-so, father's name Horen Das, 404 CL number, 406 Devodas. Father's name Horen Das, and brother's name Ranjit Das, and wife, last 409, Jimmy Das, wife of Devodas. Next, turn into page 23. He is going to change before participating in the tender. Please, it is serial number, voter I card same. My lord, please make kindly see voter I card. Page 65. In individual capacity, he put up the tender. Before that, all are going to manage. Page 65. He is going to now voter. So now, but his voter list serial number same. All are same original. And wife is also same original, but
Voter, is it voter list or voter number? What is it?
number
number.
690, but number DWM.
What is it? What number is it? Is it a vote?
In voter I card, there is a number.
Uh-huh.
That number put up with it. And turn into page. I am filing a petition after knowing everything before the managing director. He do not know anything. One or page 67. I am the tenderer. I am the highest valid bidder. 67. 67 is the petition. And thereafter, again, 28/11/2023. And my lord, very important, we have filed a officer in such police station regarding verification. Page 75. And police verified that there is given a report. Turn into page 77. Police verification report. Novodas is the same person, page 77. And thereafter, my lord, what happened? That society was defaulted. There is a division bench order specifically stated. Paragraph,
Okay, now
and now, my lord,
Ah.
they also issued notice to default the page 782, that cooperative society. They did not pay till to the 5,39,431. Now, my their judgment is regarding Lucas standard. That he is not a Lucas because he is not participator. I am the person, I am the, my lord, violate my right. This is my, at this stage, notice my prima facie, there's everything is clear case. He is going to sitting. And by police also given the report.
okay, right. Third, Mr. N. Bora. Yes.
We are not the competent authority. You see,
No, but then you have you have to also look into it. You cannot have you cannot be like an ostrich. Just put your head under the ground and say, let the world carry on. When they have brought to your notice certain facts, why shouldn't you do the basic inquiry? Basic inquiry you should do when there is a police report.
Okay.
And when there is a voter ID having the same number, two different names, why shouldn't you have the cursory inquiry done? What you want a report from the FBI or something like that? When there's a police report,
police report, this is the place here, not to the,
Huh?
this is not to the department of. The police report was.
No, no, already
council
submitted.
naturally it will be by the police. This is he has made a report to the police. So what is wrong? When you are not doing anything, at least have an inquiry. Find out whether what he's saying is right or wrong. In a murder case, you don't expect the fishery department to go and do investigation. What kind of argument is that? Anyway, right. Third, Mr. N. Bora, learned topic for the petitioner, who submits that in pursuance to a tender notice dated 14/3/22. The what fishery?
Kumotia Fishery Group. Kumotia Fishery, madam. Settlement order, page 31, madam. Kumotia Group Fishery, madam.
The Kumutia, KUMUTIYA Group Fishery has been settled with the petitioner for 7 years by settlement order dated 9/6/20. The petitioner, who was also a tenderer in pursuance to the tender notice
That's 18 to 2022.
18, the
Sorry,
date-
sorry.
the tender notice dated
14/3/2022.
14/3/22 is agreed with the settlement of the fishery with the respondent number 5, who is a defaulter. Next para, Mr. N. Bora subject that the respondent number 5 that is Debadas, is also known as Naba Kumar Das. Naba Kumar Das was a shareholder in the Kumutia Group Fishery Cooperative Society Limited, which is who who is the defaulter? Which is the defaulter? As can be seen from Annexure 18 of the writ petition. He submits that to escape the charge of being a defaulter and not being allowed to participate and not being considered for settlement of the fishery,
In individual capacity.
in his individual capacity, Naba Kumar Das had changed his name to Debadas, who is the present respondent number 5. Super. Next para. The petitioner's counsel has taken this court through the voter ID of Naba Kumar Das at page
59.
59. No, forget that. At page 63. Wait, at page 60, 61 and 63, and compared the same with the voter ID of Naba Kumar Das at page 65. Page 61 and 63 pertains to the voter number of Debadas as EWM 7238202. EWM 7238202. While the voter number of Naba Kumar Das is also the same. He has also relied upon the police verification report. No date.
Noted. On the basis of my
Police
FIR.
verification report made by the Bogamuk police station, which is to the effect that Naba Kumar Das and Debadas are the same person. Further, the ward member of Babeli Gaon Panchayat and the Gaon Pradhan of Gosain Bari lot, Gosain Bari lot, in their certificates have also stated that Naba Kumar Das and Debadas are the same person. You have some preliminary inquiry also.
Yes.
You have some. What?
They are going to benefit that. He may
Yes,
pay
yes,
all the money.
we are not,
All
anybody
the
not.
money is going to pay he. But he is this person.
We are not in favor of Damodar, anybody, Lord.
Right. Issue notice returnable in 3 weeks. Mr. P. Sharma accepts notice on behalf of
I'm on behalf of 1, 2, and 3.
1, 2, and 3. Mr. S.S. Roy, 4. Appears for point number 4. Petitioner takes care for service of notice upon the respondents number 5 and 6 by a registered post within within 3 days. This is the matter after 3 weeks. The petitioner's counsel, the counsel for the respondents number 1 and 1 to 3 can also conduct a preliminary inquiry with regard to the allegation made by the petitioner. This is that's
Mind your
The impugn order is subject to the result of the.
actually
Yeah.
the order impugned will be subject to the outcome of the repeat.
May I please? So here I'm aggrieved by the,
5 and 6 by registered pool. Yeah.
I'm aggrieved here by the eligibility criteria of the tender process. Madam, here the tender notice is there, the page number 24, madam. Clause 17. On the date of submission of tender, the bidders must not have any pending court cases against Society Kokrajal,
Yeah.
against their services.
Any citation
Not exactly, but there is something.
similar?
I will question. But
Yes,
before that,
madam.
I have to start this. Whether these pending cases for some other issue can be an eligibility criteria of this NIT. My lord.
Can be a
Can be eligibility criteria of
ineligibility criteria.
eligibility criteria of this tender. This is no.
What is
connection
the
with
case? What is the case against them?
That earlier my case, my lord. This is for the tender also, my lord. But that is for the housekeeping service.
With regard to what? Payment of dues or what?
No, my lord. That is for the NIT, my lord. I'm challenging here.
He is challenging the clause in the NIP.
Then in that cases, my lord, I was.
In that case, what are you challenging?
I'm challenging here that I was rejected.
Not here, madam, Mr. Counsel.
That,
What is,
that case, well.
yes, that case. What is that case number?
Yes, sir.
Otherwise, you're always going to get confused. WPC,
WPC, yes, madam.
WPC
2723.
5427 of
23.
23.
So yes, madam.
You have filed a case against this CIT.
CIT, madam.
What case is it?
Here, my lord, it is for the providing of housekeeping services. Here, that's providing for security services.
That is the propriety
Providing
or providing.
housekeeping services. In that case, madam.
Okay,
Where-
so then what happened? You participated in the tender.
I participated, my lord. I
You re-
was rejected.
You were rejected in the technical evaluation stage.
No, madam. In the financial.
Financial evaluation.
evaluation.
It was a 2-bit system or a single bit system?
System, yes.
2-bit system.
Yes, madam.
So you were in the financial stage, you were
I was
disqualified.
rejected.
You were not selected.
Not selected.
Or was it rejected?
Yes.
Rejected or
No,
not
no,
selected?
Not selected.
Not selected. Then what happened? Then you have made a challenge. On what
Made
ground?
challenge on the ground, my lord, that not quoting the GST on the services, madam. But in that
Not
case, I quoted the GST.
Acha, you had been rejected on the ground that
On the
your
ground
rates
not
did not have the
for the
GST.
services, sir. But that is pending this before this.
Okay,
one,
that's a
and
different-
then
okay.
interim order is operating still.
Okay.
But here, my lord, the clause 17 would, whether this clause 17 here in this NIP, the eligibility criteria is essential for the tender of this providing security services.
It's not a question of essential or not essential.
But they have put this clause 17 only to depart me, my lord. After filing that
So
case, my lord,
so they don't want persons who have filed cases against them.
yes. After filing that earlier cases, my lord, the deputy registrar told me to withdraw the earlier case.
Okay.
And they are saying that, yes, my lord, they are pressuring me to
Uh-huh.
withdraw that earlier case. They are saying that if you don't withdraw that earlier case, we are going to put a clause.
Okay,
This is-
let's
It
give,
is election, but it's true.
that issue is now, your case is that they could not have put a clause barring you from participating
They can-
just because you have filed a case against.
Yes.
That is your case.
That is,
What is the citation in support?
yes, sir. Not exactly, but this is the first paper in India, maybe, but it's 1992.
Have they opened the tender?
No, my lord,
Doesn't open.
on 7th of, this is the last,
When is the last date?
7th of March. And technical bid will be open on 8th of March. 1991, 3
Yes.
SSC,
Yes,
273,
yes,
paragraph number 6.
yes.
Paragraph number 6, sixth line, my lord. From the middle. The requirements in a tender notice can be classified into two categories. Those which lay down the essential condition of eligibility and the others which are merely ancillary or subsidiary with the main object to be achieved by the condition. In the first case, the authority issuing the tender may be required to enforce them rigidly. In the other cases, it must be open to the authority to deviate from and not to insist upon the strict literal compliance of the condition in appropriate of the case. And second is 2004 5 SSC.
How does that judgment help you? Because
Madam,
it gives leeway to the author of a tender
yes, madam, I
to
accept.
to say that this is essential, this is ancillary, and that even a essential condition can be deviated by them. That's what it says. How does it help you?
Madam, here, my lord. For providing
Okay,
security
next.
service-
Just give me the next page.
Next edition. 2004 5 SSC 364. Para number 26 and 29.
Yes.
Para 26 only. I am of the opinion that in the fact situation in the present case, especially having regard to the requirement contained in the second para of clause 5 of the sub rule 1 of rule 50 of our obtaining approval from the Central Road Research Institute or from any of the authorized agency. The further condition in NIT regarding turnover of the particular amount in the preceding year coupled with the 15 or 25% of the said turnover in the business of manufacturing license plates and also the condition regarding the experience in 3 to 5 countries are wholly arbitrary and have no rational basis. The said conditions are accordingly struck down. Similarly, in the para number 29. madam. Para 29 said
Next. This also has got no relevance. Yes. Next case.
2005 1 SCC
Yeah.
679 para
Para?
43. Para 43.
Yes.
Certain precondition or qualifications for tender have
Para
led-
14,
43.
43.
43.
Got it.
I got it, madam. 2005 1 SCC 679.
Yes.
Para 43. Certain precondition or qualification for tender who have to be laid down to ensure that the contractor has the capacity and the resources to the successful executive work. Article 14 of the Constitution prohibits the government from arbitrarily choosing a contractor as its will and pleasure. It has to act reasonably fairly and in the public interest in awarding the contract. At the same time, no person can be claimed a fundamental right to carry on business with government. All that he can claim is that in competing for the contract, he should not be unfairly treated and discriminated to the detriment of public interest. Undisputedly, the legal position which has been firmly established from various decisions of this court cited at the bar sofa is that the government contracts are a highly valuable asset and the court should be prepared to enforce tender of the fairness of on the government in its dealing with tenders and contractors.
Not exactly
Here,
the point.
but here I am not giving the fair chances to participate in the tender.
Okay, yes.
my lord. That would not.
That's all. That's all. Yes.
Your lordship, it is a general clause they have included preventing that it is challenging lordship. So lordship, it is cannot be said to be to any bias against him.
What? It is not biased.
Lordship.
Why?
So it's maybe it may be for other also lordship. It's a clause in the.
Isn't it violative of Article 12 and 14? I can understand if he is blacklisted.
Yeah.
Well, how can he be just debarred from participating?
One thing I
Why?
want to submit lordship whether in previous and I think that he had challenged the stay order is there, whether such types of clauses were there.
Madam, those issues are different. That issue pertains to particular case. Just because somebody you don't like him or you have been insulted by his filing a case against you, you bar him. Oh, you're a state. You're not a private body. You have to have broad shoulders. You're the government. Government cannot look at persons individual in the individual capacity. You've got to look at them as a government, as a mother and father of everyone. And can you bar someone from pursuing the legal remedy which is allowed as per law? They are pursuing it. They're not doing. They're doing it as per what the law allows them. How can you bar them from participating just because they have gone to court? I don't think this is correct at all.
This is the stay order, my lord, that the earlier case. In the public.
How does it matter?
That case is.
That's a different issue, Mr. Counsel.
Yes, my lord. Not because of that.
Just a minute, please. We have heard you.
Fine.
Yes, you allow them to participate. I can dispose of the matter now, but we'll give you chance to think. But you allow them to participate. I don't think prima facie. I don't think you've got a case, and I think this clause has to go. They are pursuing the legal remedy. It is not an illegal remedy. It is a legal remedy that is open to them. Can you bar them because they're pursuing the legal remedy? Tell your client. I think this kind of attitude and this kind of mindset is, it's like having a big ego. Then they do it. I don't think it's allowed. Right. Heard, Mr.
A borrower.
A.M. Boro,
Yes, sir.
learned counsel for the petitioner, to submit that the petitioner has been barred from participating in the tender notice dated
15/2/24.
in the notice inviting e-tender. Hereinafter referred to as NIT, dated
15/2/24.
15/2/2024. In view of clause 17,
Clause 17. Of the eligibility criteria.
where? P?
Page number 23. 24 is the clause 17. Page 24, clause 17.
In view of clause 17
17
of the
of the eligibility criteria.
eligibility criteria, which states that bidders must not have pending court cases against CIT Kokraja, that is the authority which issued the NIT. The petitioner's counsel submit that the said clause is illegal and hit by Article 12 and 14 of the Constitution, and as such should be set aside. Issue notice returnable in 4 weeks or 3 weeks. 3 weeks. Issue notice returnable in 3 weeks. Miss S. B. Sharma accepts notice on behalf of
All that.
all the response. On a perusal of the readings and the issue raised by the petitioner, it is seen that the petitioner had participated in an earlier NIT dated 26/6/23 issued by the CIT Kokraja for providing housekeeping service to the same. The petitioner was not selected at the time of financial bid evaluation stage, on the ground that the rates quoted by him did not include the GST rate.
Is the one service. Sir.
GST rates on the services, on the service amount quoted by him. Being agreed by the same, the petitioner had filed WPC 5427/2022, which is still pending before the. On considering the fact that the petitioner has pursued a legal remedy with regard to his grievance in respect of another NIT, This court prima facie is of the view that the petitioner cannot be barred from participating in a subsequent NIT. For, what is this for?
For providing security services.
For providing security services to the CIT Kokraja. Accordingly, the petitioner shall be allowed to submit his bid in terms of the NIT dated
15 to 24.
15 to 24. So stop. Though the selection can be, though the respondent shall be allowed to continue with the selection process. The final acceptance of the successful tender shall not be made without leave of this court. This matter on, give it.
Publication.
What is the? Give me, I think you need a lot of,
Stuff like that.
huh?
That-
She has got a monopoly over these cases. But all of them, I think in one of them that admission is not there.
Lordship, I have all.
You have got, no. The parties are the same.
Lordship. Scheme is also same.
Miss A. Dayan, Ardeka, okay, they're all there. Then out here the petitioner's case. Then the scheme is same for all of them. This scheme itself,
Same lordship.
are you sure?
Yes, lordship.
Okay, scheme is same. What is the amount in the first one? Let us see.
995,000. That is at page 15, lordship.
Then the letter number will be different, I think.
Lordship, that number will be different and the amount will be
Letter number
page 13.
7/20/23 2/3/8 21. Okay, but this is done.
Item 10 is also similar.
Which one?
Item 10.
Let me see.
Page 15 is the last.
That is 4 lakhs. Correct. 4 lakhs 54,000.
Yes, lordship.
What is the date? 8/9.
8/9/2023.
The scheme is the same
Yes, the scheme is same.
for all the cases.
Yes.
Next.
Page 15 is the liability statement and relevant part is in page 16. Lordship.
Page 15.
16. The amount. The letter is at page 13.
Two, three, two, one. Yes, next.
Page 14 and the 16.
Oh, there's quite a bit.
Same scheme.
Safety. Just because the number is completely different. Huh? Where is the forwarding?
Page 13.
Oh, no, tell me one thing.
Same scheme, Lordship, different work order. There's two work order.
Two orders.
Yes, Lordship, they issue two liability statements.
This one has to give separate dictation, huh? This will go dictation to my, have to two work orders, have to do separately. In my chamber. This
I can tell you.
20. Where is the admission?
But page 12. Liability statement is page 40.
Okay.
Okay.
So you'll have all seen the petition as per timeshare earlier.
No, Your Lordship, as per
As per that other, yes.
Obliged.
This is mine. No, this is not this one. Not this one. No, give it back to.
My lord, here in this case, my lord, the grievance raised in this petition is that he has been marked as a key voter in
Item,
the list.
voter, the voter.
Look.
We get the opposite. Okay, right. Heard, Mr.
Yeah, Chief.
K.R. Signal, learned counsel for the petition. Also heard, Mr.
G Sharma for respondent number
D. Sharma.
G.
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 G. Sharma for
2 and 5 Lord.
2 and 5.
I am for 3.
Mr. S. S. Roy appears for number 3. And
I am for electron, sir.
what's your name?
D.
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 E.
T.
T for Timbuktu.
Telangana.
Okay. T. Pegu. For his point number
4.
4. So Superintendent Police will be 5.
Yes, Lord.
Volpara.
Yes.
Where is your voter ID? Let us see.
But no voter ID has been issued to me
Huh?
because I have already marked as a D voter. So D voters are not issued, my lord. My lord. Voter list 1997, my name is here.
Where is
Yes,
the voter
yes.
list page?
Page 39. It says there, Malina Pani. Actually, my title is Datta, but I am married with my husband is Jivan Boni. So I acquired the title of my husband.
I don't know. Let them look at that. Hannah, do we have to mention that?
But one thing, my lord, admittedly, the family migrated from East Pakistan. Right? Her name is in the eligibility certificate. In Annexer 1.
Where is the voter list? What voter list is for what? For which? For which?
Page
For
39,
which legislative assembly constituency?
my lord.
There's nothing mentioned.
My lord, the 36 number, Dudnoy ST LSC. My lord. Yes, my lord, there is some omission. I'm sorry, my lord.
What?
Yes, my lord. It should be 36 number, Dudnoy, within bracket.
Where do you get that? Where do you get that?
My lord, in the page 40, my lord, it's vernacular. But translation, there is omission, my lord.
What? Don't know it? In respect of
36, Dudnoy, within bracket ST,
36. Don't know it.
Dudnoy, within bracket ST, LSC.
Don't know it. ST,
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 yes, LSC,
LSC.
Walpar.
Valpara.
Yes.
So foreigners tribunal भी है.
My lord, Walpar.
So let the SP verify. And then it can be referred to the foreigners tribunal
After verification.
after verification.
My lord, if my lord, SP request, my lord, my personal hearing will be taken.
Let him decide.
Keep lovely.
It is your lordship. Lordship is pleased to look at order dated 26th of February.
Yes,
There is a direction of the personal appearance of the director.
yes.
So she is present, lordship, and we have filed a detailed affidavit of that. Whatever role she has to play for payment of the amount, lordship, she has done it long time back from 2022 onwards. The problem here is that lordship is pleased to take the contempt petition, page 10.
Yes.
So there are two central, one is the first party is the state government principal secretary of the department, then union governments, two officials, one official, then there is a director. And in the contempt petition, they have only filed a case against two central government officials, 2 and 3, and one is a director.
Yes.
The director's role is extremely limited. She has to do the verification, and in the verification, it was also found that out of 31 lakhs, their table is about 22 lakhs. And she sent all the communications for release of the fund. The proposal, this whole scheme was initially, it was a central government scheme. Then later on from 2018-19, it has become 90-10, 10%. Now nobody is taking it seriously. I have spoken to the principal secretary now. So they are now reopening because the central government has already closed that account and everything. So nobody is taking it seriously. So the proper person should be made party here. One is the principal secretary of the state government and the central government officials, because the ball lies with them now. She is totally helpless.
He has done everything.
She has done everything. Even Lordship put her into jail, also she won't be able to, unless they act.
No, we are not on
And I'm
that.
just
Yes.
on a lighter vein, I'm saying. Because that is why they should have made all of them party, especially the principal secretary of the state government, whose responsibility is 10%. Even then, if the central government is not paying, the state government will have to pay.
Correct.
So,
Another thing actually out here is that you see, they are saying that they said in the earlier round,
Lordship,
they were saying that claims of the petitioner had been found to be objectionable.
yes,
Now,
that is objects that,
They're while looking at the chart,
Lordship.
some claims they found objectionable, that is okay. But some claims were admitted.
Exactly, that is why out of 31,
Ah.
22 lakhs is payable.
So whatever is admitted should be paid.
Yes, Lordship, that
That's
is what she has undertaken also.
Okay.
Because the direction, if Lordship is pleased to come to page 12 of the contempt petition,
Yes.
Does the last paragraph, does the issue relates to non-payment of outstanding dues to the petitioner in respect of the part payment which has been made by the respondent authorities, central government and state government authorities. Now next paragraph. In view of above, the writ petition is disposed of with a direction to verify the claims of the petitioner, and if same is found to be genuine, necessary steps are to be taken for release of the balance payment fund due to the petitioner. The entire exercise must be carried in 3 months. So she has done that part, verification, everything, and she has sent a proposal for giving 22 lakhs. Total identically placed case, Lordship, the director, the principal secretary just told me that is about 8 crores. And central government has also agreed that they will work out something, and after the election, they will do it. But that is the verbal thing. That will not help.
You see, one thing is that we were not very keen on having her here.
Lordship.
The issue was that on the last day, the council was saying that these are objectionable claims. So we showed him the chart where they have said objectionable claims are these and admitted claims are these. I said, when there are admitted claims, you cannot say everything is objectionable. So to clarify that issue, we wanted her.
The 22 lakhs is admitted in our affidavit also. So
So I
my
think-
submission is first that let them make the principal secretary of the department of the state a party, and also the competent authority. If they are the competent authority, if they are represented, then it is fine. Because the central government has also taken it to consideration. Not only this case, the other cases also, they will do one-time relaxation to open the account and give all the dues in 3 months. But that is on verbal. So let everything come on affidavit, Lordship. And they should also get what is needed.
Correct.
Lordship, the central government has already filed an affidavit saying, Lordship, they have closed this entire thing,
Yes.
because
They are going to reopen.
No, no, now he said the AG said they're going to reopen, and then the issue is that they have to pay when they have asked you to work. Only thing is that the admitted amount will have to be paid only, not the objectional amount. The objected amounts, you have other remedy.
other image. Lordship will kindly indicate that in the order of it so that we can implement
Complete what?
the principal.
Yes, yes,
secretary.
yes.
They are here already in the main, in the judgment.
They have not choose not to implement them.
Because the
That creates a
direction
problem.
was, because the director and Lordship,
The hierarchy director is quite below
Correct.
regarding the financial aspect.
No, no, the thing was that there was some miscommunication from the counsel for the respondent with regard to how to interpret the objectionable claim. So that was, so we wanted the director to clarify that. Because that is not the impression that we got when we read the affidavit.
now
Anyway,
Lordship, the department is also bifurcated, Lordship. Now Lordship, it is, earlier it was labor department, now it is Lordship, skill development and entrepreneurship.
so which
that
department
was
will it be?
Skill development and entrepreneurship. Because we have made a party earlier, that is Department of Labor and Employment.
Secretary will remain the same.
Yes, sir. Lordship, in 22nd February 2022, she wrote with the verification report and everything, where she said 21 lakh 13,000, all these things. In our affidavit, all these are part. So that was done by her on 22nd February 2022. Submission for proposal of the state government's role sanction is 10%. On 22nd February, she complied it immediately, actually.
Where is the affidavit? Today's affidavit we have filed.
It has come.
Is it? This is the one. Right. Mr. S.K. Das appears for the petition, while Mr. D. Cycling appears for the Director, Employment and Craftsman Training, SM, who has also appeared personally before this court in terms of the last order. System. Mr. D. Cycling, the learned senior counsel submit that the director has already complied with the already complied with the order dated 30/07/2021, passed in WPC 4709/2020. by way of a speaking order dated 13/7/2022. No, don't say by way of speaking order, you cut that by way of. He submits that the state government is taking up the matter again, even though the matter had been, even though uh, the scheme had been closed by the central government. He also submits that the petitioner will be paid all the admitted amount. Further, release of funds had been asked for by letter dated 1/3/2020 to the state government and to further take up the matter with the government of India for releasing the balance amount payable to the petition in respect of the admitted amount. The House submits that the petitioner would have to be paid the admitted amount. That's all. Next. Then you file an application for impeachment. I have seen the affidavit in opposition filed on 4/3/2024. And I also find that the head of the department has not been made a party in this contempt petition. Mr. S.K. Das, learned counsel for the petition, submits that he will file an application for impeding the head of the department. Anybody else? That's all I think.
Lordship, only clarify Lordship, whether it is the labor and employment department. Will give them. Or it is the skill development entrepreneur. Because subsequently it has been
Yes.
bifurcated.
So who is the
property.
no. Who will be the
The
who will
department's
department?
new name is Lordship, Skill, Employment and Entrepreneurship Department.
Okay, that's right. Mr. Mr. D Cycle and Senior also submits that the concerned department is the
Is Skill, Employment
skill, employment
and Entrepreneurship Department,
and entrepreneurship
headed
department
by the principals.
headed by the principal secretary, who is the nodal department with regard to the present matter.
Highly obliged.
Accordingly, with this matter after
1 week.
after 2 weeks. After 2 weeks, the personal appearance of Srimati Kasturi Bharali, Director, Employment and Craftsman Training, is what is the word used?
Dispensary.
Dispensary.
At this stage.
Dispensary.
Highly obliged.
Thank you.
Alright.
Item? Oh, Mr. Islam, long time.
Yeah, next year 6 page. 23 minutes.
With you, I have to be slightly more careful with the documents.
Hello?
I have to be slightly more careful with your documents. I remember those preferential appointment writ petitions that you had filed earlier. Yes, what is your case?
My lord, total amount, my lord, 4,74,486.
4,70,000.
4,74,486 rupees. What was done, but 1,08,600 was paid. Area amount, my lord, 3,65,886 rupees. was paid.
886. Okay.
Liability page,
Where is the admission?
liability statement is page 23, the next 6.
What is to be done?
Not a part zero.
Huh?
Union of India is not a part zero.
Yeah, window.
I have also to take instructions.
Okay, right. Third, Mr. B. Islam Learned Counsel for the petitioner who submit that the petitioner has not been paid his contractual dues amounting to rupees 3,65,883. Issue notice returnable in 4 weeks. Ms. B. Deka,
Respondent number 567.
accept notice on their response number 5, 6, and 7. Who else? Who else? Who is for 1, 2, 3? You'll be, Miss Deka, you'll be from 4 to 7, correct? 4 to 7. No, for 3 also, I think. Yeah, 3 to 7, huh? Miss Yudas, accept notice on their phone number 1 and this is the matter of the case.
Develop.
Your lordship. This is the case of non-payment of contractual dues amounting to 69,544.
How much?
69,544.
69,000,
544.06.
44.0?
Six.
06, so you can, I think you can leave it, no?
Yes,
You still want 06 also?
Sure.
Yes, where is the admission?
Completion certificate is at
Admission.
your lordship. There is no admission. So
There's no admission.
notice at this stage. Similarly situated petitioner was before your lordship. And your lordship had issued notice in that WPC 612.
Okay, anyway, so we'll issue notice. Miss B. Chaudhary, learned counsel for the petitioner submit that the unpaid contractual bills of the petitioner amount to rupees 69,544. Issue notice returnable in 4 weeks, Mr.
I bought
I bought Hakur accept notice on behalf of
PhD.
PT department. This is the matter of the phone.
Lordship, there is a typographical error in page 8. I may be allowed to correct.
I don't think so. You cannot. By hand is not allowed anymore, madam. The problem is that the CIS, we cannot upload. It has to be, everything has to be done by way of amendment now. Amendment, then you've got to file amended copy. Or you can withdraw and file a fresh.
So Lordship, fine.
Then it'll remain like that only.
My lord.
Official lordship. Matter relates to non-payment of contractual. Liability statement is at page 38.
28.
The amount of 44 lakhs, 30,990.
This is again that, what is this? Oh, what is the, again that Kopili junction?
Yes. Same, your lordship. Union is not part zero. I have also to take it.
The problem is Union of India is not a party here. But if Union of India is a party, then we can dispose it of.
That's
Best thing is what you do, you withdraw it with liberty to file a fix, make them make them a party. Otherwise, you can file an application for impediment. That will take time. Impediment, then you have got to allow your application, you have to file amended writ petition.
We may be allowed to do.
Mr.
G. Ragman.
G. Rangma, learned counsel for the petition, says that he may be allowed to withdraw the writ petition with liberty to file a fix. Fair is allowed. This petition is dismissed as withdrawn, with liberty of fix.
Your lordship, finally the matter may be passed over 40 days. As the engaged counsel, she has to leave the court due to certain medical.
Yes, Mr. Gupta, what is to be done here? The statute provides that, my lord, the authorities have already exceeded the period for another 60 days. Under the act, my lord. And beyond that, there is no scope. And
There was a full and final claim
No.
for payment of rupees 5 lakh.
My lord, against that order, they have prepared an appeal before the appellate authority, my lord, under the payment.
No, full, that was by the Supreme Court, I think.
Yes,
So where's the question of appeal against the Supreme Court order?
no, my lord. Subsequent to that, my lord, they have raised another claim, my lord. That is not, my lord.
Gratuity,
Yes,
for gratuity.
for gratuity. On the basis of the amount paid. Granted. And the application for condonation has been rejected, my lord. The appeal has been preferred. Against that rejection, they.
How many days delay was there? You've got no idea, no clue.
It's not.
746 days, my lord.
Right. This writ petition has been filed as the delay of 746 days. Delay had not been, and the delay of 746 days had not been condoned by the learned tribunal,
No, it's an appellate authority under the payment of debt.
by the appellate authority under the Payment of Gratuities Act.
And the Deputy Chief Labor Commissioner, Central Guwahati. That is a designation.
Pusta. A genuine prayer has been made on behalf of the petitioner's counsel, while Mr. A.T. Gupta appears for the respondent. No, don't say Mr. A.T. Gupta. Accordingly, leave this matter after review.
May I please, Your Honor?
Yes,
Lord, pursuant to a notice inviting a tender for supply of computer tablet, the petitioner firm has submitted his bid. And his bid was accepted and a comparative statement was made. Lord, the petitioner was the L1 bidder. Lordship may kindly see page 51.
yes,
And petitioner was the L1 bidder, Lordship, then write annexure 6. The petitioner firm was issued letter of intent. And thereafter, this letter of intent, after issuance of this letter of intent on 16/2/24, the website of the respondent number 1 shows that the letter of intent has been cancelled. So he immediately filed a representation to know as to why the letter of intent has been cancelled. The Lordship, and he was informed by
due
the
to some reason.
due to some reason. And later on, he has been served with a communication dated 21. That is 21/2, that is annexure 8, that his bid has been cancelled
Due to some reason.
due to some reason. Lordship, this is very arbitrary. It was incumbent on the
Yeah,
part
I
of
heard Mr.
MP firm.
P. Warming, learned counsel for the petitioner who submit that in pursuance to a tender notice dated
Lordship,
An
extra
Huh?
Yes, tender has been issued on first of the parts.
one,
Two tenders have been issued for the same.
then you don't open anything, don't, how can you
I
do this?
understand, madam. The GEM is a, madam, national party. They
I
are
have
the one-
included respondent number 1, GEM is respondent.
we are
number
not-
one. GEM is respondent number 1.
No, no. we are not-
Yes.
No, GEM is not a party.
The GEM is party, Lordship, respondent number 1.
Respond number one, Union of India,
Yeah.
represented by Secretary, Ministry of Commerce.
Secretary, Ministry of Commerce is the director of GEM. I made a statement, Lordship will kindly see.
Mr. Counsel, you should make a separate party altogether.
Lordship will kindly see paragraph 2 of my writ petition.
Maybe, but in the cost title,
Lordship, the Union of India represented by the Secretary, Ministry of Commerce.
Mr. Counsel, that is the Union
and
of India.
Nominee
Maybe,
director,
he,
government.
you see, he's not only chairperson of GEM, He'll be a chairperson of many other committees and many other authorities.
Yes.
That doesn't take away the fact that respondent number one is the Union of India. It is not GEM.
Yeah, but
But that's the question of but, Mr. Counsel. Number one is the Union of India. It is not GEM.
yes,
Then
but the secretary.
you make it a separate, you file a separate, you make GEM a separate party altogether.
Yes, I do.
You do that.
But meanwhile, I am praying for stay of the order lot.
Not even Thursday, my lord, because my lord, in the new tenders, my lord, it is on 11th is the last date of submission of bid. So I pay on my lord, at least not to be considered till my lord Thursday.
Till then,
Nothing
the
will happen
shipping order
other-
may be stayed.
Because
Because
the last
Lordship,
time-
I have already revealed my trade secret. The price at which I am going to submit at.
This is regarding my lord,
Mr. Counsel, you want to stay the GEM thing. GEM has to be party.
No, the tender has been floated on behalf of respondent number two. Lord.
Huh?
No, impugn order has not been passed by JAM. It has been passed by the respondent number two, Lord. Impugn order has been passed by the respondent number two, Lord.
my lord will kindly turn to page 57 for a moment.
Yes.
In inviting a reference to the subject cited above and bid under reference, you are informed that the GEM admin has cancelled the above. Not by SSA, we have only intimated him.
Lordship, whereas JAM has informed that they are not authorized to cancel. He is the bidder who can cancel. Lordship will kindly see Annexure 8, page 55.
Some reason.
Lordship will kindly see Annexure 8, page
Just a minute. Mr. Counsel, why don't you just withdraw, file a writ petition by tonight or by tomorrow morning, and then you list it. And it takes care of everything.
Lordship, meanwhile, I have submitted my bid, Lordship. I have revealed my trade secret. The price at which.
Mr. Counsel, have you heard what I've said?
Yes, I have.
Then, when is the tender going to be opened as per the new tender?
11-3.
11th, you have still got time. You file it by today, just add that. And or by tomorrow, you make a mention. You have got a case, no doubt about it. You've got a case as of now, provided what they're going to say, we don't know. But you make them a party, then it clears up everything, otherwise it will be a problem. You do that. Otherwise, it's causing a slight problem here.
My one is my lord 11-3, other is 9-3. So by tomorrow, if you file,
Correct. Today is 4th. Today is 4th.
Yes, Lordship, I'll do.
You do that. Mr. P. Bhaumik, learn counsel for the petitioner, pays that he may be allowed to withdraw the writ petition with liberty to file a fee. Pays around. Is the writ petition dismissed as withdrawn, come out with liberty of fee. You just do that. That's all. How does it what's so difficult? I don't know.
They will be.
Head Peter. My lord, without going to the earlier controversies, if your lordship will kindly come to page number 46, that's the resettlement order.
This is right. Page number?
46.
Yes.
The original is at page, my lord, in particular in 49, we have given the English translation. In connection with the above subject, I have the honor to state that as you fail to deposit necessary amount of money within the stipulated time in response to order dated 27/7/22, in connection with management of Fishery Mahal, situated in Morigaon subdivision of Morigaon district, the offer for settlement of Mahal fee was cancelled by order dated 7/7/23. You filed WPC number so and so in the Honorable Guwahati High Court against the said cancellation. And since you have deposited the earnest money security for so and so, your first installment of revenue and bank guarantee for the year so and so, As per the judgment, it is 31/7/23, passed in the said repetition. Management of Nin Mahal is given to you for a period till 31st March of the seventh year, that is 31/3/29. You will be bound to comply with all the terms and so, my lord, I was again resettled. Now, my lord, till that possession has been not given, and they're demanding the revenue for the period where I was never put into possession. My lord, our High Court judgment is there, my lord, on this point.
He has not been given possession.
Yes, I was never given possession.
Yes,
My lord, to kindly go to page number 50, lord. My lord, will kindly come to para 8, my lord.
para 8.
Yes, of the judgment.
Yes.
Second, third page, third line, my lord. Para 8, third line. However, in no circumstance, it can be construed the demand of fish money for a period where fishery was not even in possession of the petitioner can be said to be legitimate demand. This observation is irrespective of the fact that even in a given case, if there was absence of fishing activity, but if the possession is still with the settlement holder, the incumbent would be under a legal obligation to clear it. Supposing, my lord, possession is
No,
given.
no, I get it. I get it. Let me hear the other side. Yes,
May I please? May I, lordship?
yes, yes.
Lordship, kindly go to page number 14, lord.
14,
14 of their picture.
1/4.
1/4. What they have stated in the petition, that the petitioner humbly begs to state that soon after depositing the prescribed revenue for the Mean Mahal, by a petitioner to the respondent number 2, and after issuing allotment letter, the respondent number 2 had handed over the Mean Mahal to the petition. Here, lordship, position was been given. They have stated in the petition itself, lordship. But at the time of handing over the Mean Mahal, it was found that the land area and water area are reduced to 1/4 of the area stated by the respondent number 2 in the advertisement. At that time, respondent number 2 had promised that the entire Mean Mahal will be demarcated and the actual area of Mean Mahal will be ascertained and handed over soon after fulfilling the terms and conditions. It was their statement, lordship. Regarding that part, lordship, that whether there is enforcement or not, lordship kindly has to turn to page number 58.
15.
58. Lordship, this is the document.
58 is in vernacular.
Yeah, that is the very vital thing, lordship. Yeah. No, I'm translating it. 58. This part was not translated. Before here, lordship, it is stated that the second part, because the agreement executed with the petitioner with the AFTC lordship. Here, lordship, there it was stated that the second party cannot claim for any loss due to that is called encroachment or everything. So here, lordship, yet
Second party is the petitioner.
as part of it, they cannot claim anything. As per this clause, they have to first challenge this clause number 23 because they have executed and signed that if there is any as is where is basis. We are giving since 1976 law. If there is any encroachment, they have to take it. The enforcement part is.
So now, okay.
Here, lordship, one major thing, lordship.
So
Yeah.
basically, they have been given possession.
Yes, lord, that part,
Only thing is that they have not been given possession of the entire area as per the petition.
yes, lordship. But here, lordship, it was not.
But as per the agreement, even if they have not been given the entire area, they still have to pay.
Yes. It is clause number 23. That
Clause
clause has to be changed.
And now what is so they have not paid any money till now, any cash money.
No, they have paid lordship. The actual part is that in 2022, we have given settlement. They have given very privileged. This petitioner has got a privilege lot from the agency lordship. Because in 2022, they have given settlement, but he was supposed to pay within a stipulated period of time. They have paid half part, some part. Then in 2020, they came up. We have cancelled it. Then they came up before this honorable court. We stated yes, they have given around 30-40 lakhs. I don't know the actual amount. Huge amount, otherwise it will be forfeited. So we given some said, okay, we'll settle you. So the authority decided that okay, you run the fishery, but give us the money. So now they are not paying and they are coming.
Oh, what is the prayer here? Where is it? Where it is? To demarcate the area to exempt the petitioner from requirement payment.
To market the area of the Udari Mean Mahal, exempt the petition requirement of payment of revenue for the year 2020, and state aside that was an imprint demand order. We have demanded money lot. We have not yet set aside. Now we have not cancelled as of now. He still, and we have just demanded the money. It is not sure that I don't know whether the authorities will cancel it.
So he's challenging the demand one.
Demand.
Demand.
Well, Lordship may can take instruction Lordship.
No. Yes.
My lord, kindly come to page 62 for. It was in response to this, my lord, letter that interim order was issued. I have the honor to state that I am the lessee of Udari Mean Mahal. The bid for settlement of Mean Mahal was done on 20. Assam Fishery Development Corporation made the offer of settlement of the Mean Mahal to me. Accordingly, I deposited security money and revenue of first year installment as per the rules of the corporation. Though I was supposed to submit bank guarantee, that is 30%, I deposited an amount of 10,75,000, could not pay the remaining amount. Hence, corporation cancelled the offer of settlement of Udari Mahal. Therefore, I filed writ petition before the Honorable High Court. The High Court passed an order giving settlement to me for giving 7 years by receiving 9 lakhs from me. I have submitted the bank guarantee to the corporation in compliance of the order of the High Court. Though the corporation made final offer on 29/9/93, the contract was executed in the office corporation. Mean Mahal has not yet been handed over to me. Now, my lord will kindly come to their reply at page number 65. They're referring to the application dated 8/11. I have the honor to state that you submitted the above mentioned application praying for permission to carry out developmental work in Toronto, which have been under your management at your own expenses. Your application was specifically considered, and though the decision was taken to permit you to carry out work keeping in development of Mean Mahal in view, the permission cannot be given to you as an amount of 20. So, my lord, public order publicly made has to be construed in the context in which it is made. Now, what is the ground of the refusal? Refusal is you have not paid revenue for the year so and so. Is it their case that we are a defaulter? That in spite of operating, we have failed?
But at the same time, what about your pleadings at para 14?
No, my lord, it was, my lord, there are different stages. Sometimes what happens, initially they give us permission to develop it. Fishing season starts at a particular point of time. My lord, formal permission to fish was never given. Because it is no question of giving, because there was some default in payment of the, my lord, his money, that security amount of 19 lakh. I could pay only after the subsequent order of the High Court. My lord, end of the day, it's a court of equity also, my lord. Yes, there was some default on my part, but by the last order, all these were regularized. Now, after the Honorable Court's order, can they take such a stand? That's my only point, my lord. And there is no dispute that there is, my lord,
No, you are saying that you have not been given possession.
yes.
Now let
No, my
us,
lord, I was never given permission to freeze by handing over formal possession. Let them show a document, my lord. Let them, my learned friend from the record show that formal possession was handed over to me. Let it be fixed on another day. It is in the record, lord. In India, petition itself, agreement was executed, lordship. It was not being translated fully. Well, agreement we are not disputing. Agreement, even when this time also we have executed. Earlier there was no agreement. This time there was agreement because I paid the money. We have given possession, and we have informed all the DC, FP, OC, everybody that we have given the position. And here in the petition itself, they are saying that they have taken the petition, position. Their only grievances is the 1/4 of the area is under illegal occupation, encroachment. And that part is being covered by
where have they said that in para?
page number 14, Lord.
Page 14.
I just referred, Lordship. Para 12, Lordship. That the petitioner humbly begs to state that soon after depositing the prescribed revenue of the Mean Mahal by the petitioner to the respondent number 2 and after issuing allotment letter, the respondent number 2 had handed over the Mean Mahal to the petitioner. Lordship, here their main grievances is clause number 23, they have to challenge it.
No,
They
my,
have signed it.
my learned friends should complete the paragraph, my lord.
Yes, but and yes, I have earlier I have completed, but at the time of handing, I have stated repeatedly, handing over the minimal, it was found that the land of the area and water area were reduced to 1/4 of the area. Stated by the respondent about twin the advertisement. At the time of respondent, they have promised the entire mean mahal will be demarcated. This is the verbal assurance. That part I want to say. This at the time of respondent, they have promised the entire mean mahal will be demarcated and actual area of mean mahal will be ascertained and handed over soon by fulfilling the terms and conditions of the agreement.
Yes. That is the background.
No,
Please,
but once
please come to page 61
Lordship,
for a
yeah.
moment, my lord.
And thereafter, I will refer to page number 58, that particular part, that where they have signed, that if there is any encroachment also, they will pay.
Page 61.
Yes.
Now, MD is writing to the deputy commissioner. With reference to the subject cited above, I have the honor to inform you that Arbitrary bill falls under administrative control of the APC. The corporation has leased out the bill to so-and-so for a period of 7 years. A petition has been received from Biren Mazuna pertaining to unauthorized fishing carried by some persons illegally in the above mentioned bill. A copy of the petition is enclosed herewith. In view of above, you are requested to kindly direct concerned circle officer to take necessary action to stop unauthorized fishing as per law in the said bill for greater interest of the SC company. So my humble submission is, my lord, let my learned friend obtain the instruction as to what the circle officer's report says. And secondly, my lord, document to show that formal handing over of the possession was given to us. We are not disputing that the agreement was signed because the agreement we have annexed.
No, where's the question of formal
My
document
lord,
required?
my lord,
When you
every-
yourself,
in every fishery settlement, my lord, there is a formal handing over.
no, I'm not on that. You see, when you yourself have stated
Ah.
that you have been handed over possession,
No, my lord,
why, what is the requirement?
my lord. Yes, it is there. I cannot dispute that. But kindly read the paragraph as a whole. My lord, maybe under misconception also this statement could have come in, my lord. But the question is, you lordship will ascertain whether formal handing over has taken
No,
place.
you yourself have stated, why
No,
should I disbelieve what you're
I say
saying?
is, my lord, at the time of handing over, I could notice that also it can be inferred. Kindly read, my lord. But at the time of handing over minimal, it was found that the land area and water area are reduced to 1/4 of the area
Correct.
stated by the respondent number 2 in the advertisement.
Correct. So you have not been handed over all, but you have been handed over 75%.
No, my lord, what I'm saying is, that at the time when it was handed over, when I noticed, then we objected. Then MD also writes to the, my lord, deputy commissioner. Please inquire about it. So my lord, my learned friend is making argument as if he has got all the instructions. Going by the nature of the allegations we have projected, I think it calls for some instruction from the authority as to what is the actual state of affairs.
What about clause 23 of the agreement?
My lord, that I
Neither-
can deal with legally, there is no problem, my lord. So many Supreme Court judgments. These
No,
are all
no.
dotted line arguments, agreements, my lord. I have got no bargaining power. I have to sign it. That doesn't mean they will enforce it against them. If
But-
that is the, if he,
Okay, but as per this page 14,
yes,
para 12, according to you, 75% of the mahal has been handed over.
no, only 25,
No,
1/4.
are reduced to, okay, 1/4, okay, are reduced to 1.
My lord, perhaps what it was thought to be conveyed was, my lord, at the time when it was given, we could notice that only 25% area is there. That is what we are trying to put. So lordship will keep it for Friday or next Monday, sorry, Monday or Friday is a holiday. Let it be on next Monday, let my learned friend obtain instruction. On that day, lordship will consider the prayer for infantry.
Okay.
Two aspects, my lord.
Okay, you obtain instructions.
Yes, and especially
Notice
page 61.
Notice may be issued.
Yes, we need to notice.
Notice.
And for infirm orders, my lord.
Heard Mr. K. Chaudhary, Leonard Senior Counsel for the petitioner to submit that though the fishery has been settled with the petitioner, the possession of the same has not been handed over to him. As such, in the absence of the handing over of possession of the fishery to the petitioner, the respondents cannot ask for payment of the revenue for the fishery. On the other hand, Mr. P. Sharma, the learned counsel for the FDC submit that as per para 12 of the writ petition, uh, some portion of the fishery has been handed over to the petition. And in terms of clause 23 of the agreement executed between the parties, some of which has not been translated, the petitioner is to pay the revenue for the fishery, even though he might not have been handed over 100% of the fishery.
If there is any enforcement, if there is any.
Or if there was any input. Mr. P. Sharma shall obtain instruction as to whether, no, issue notice returnable in 4 weeks.
But let it be 11.
Huh?
I'm praying for interim order. And meanwhile, they will not, cancel the lease by law, or till your lordship takes a call there. They will not cancel, they themselves said they have not done it.
Release the matter on 11. Release the matter on 11.
15
On which date Mr.
15
P.
March,
Sharma, huh?
15 March.
15 March, okay, 15 March. On which date Mr. P. Sharma shall, by which date Mr. P. Sharma shall obtain instruction with regard to how much percent of the fishery has been handed over to the petition.
And my lord, the faith of that letter issued by the MD to the deputy commissioner regarding inquiry, page 61 letter. Where the MD
And as
himself
to,
signed.
and as to whether, and as to the fate of the, wait, page,
Page 61, my lord.
and as to the fate of the,
Letter,
and as to the fate of the letter dated 11/10/2023 issued by the Managing Director AFDC to the District Commissioner Marigot.
yes. Highly objected. For consideration of interim orders on the.
We'll see, will be there.
Highly objected.
Okay. 21 to 23.
Under the petitioner said it.
Huh?
The petitioner is the contractor where.
This is unpaid contractual bills or what?
Disputed, though.
Disputed,
Disputed.
disputed amount.
Disputed. And another thing is that there is also already an arbitration clause, but I have not been able to bring the entire contract papers on record. Lordship allows me some time. I'll file additional affidavit to bring the contract papers.
No. Is it a disputed?
Yes.
Are they disputing the amount?
In fact, they are yet to give us the final invoices.
Oh,
The invoices are yet to reach the IOCL.
so let us hear. Yes. If it is a disputed amount, can this court decide?
That issue is already there.
Well, it is a. Well, so far this disputed.
If a lordship will just come to our affidavit page 27, everything is clear, the last page. Affidavit filed by the respondent Indian Oil Corporation, page 27.
Page 27.
27.
Yes, I've got it.
This is the letter from the IOCL to the contractor of 2021. Subject submission of final bills regarding.
Wait. Page 27. That
Page
is
20.
para
So it's a annexer. It's a document
of the.
of the affidavit filed by the respondent or Indian Oil Corporation.
Page 27. Yeah, I've got a running page
Oh.
27. That is the thing.
I
There is no 27 here. Even the
the third last page of the affidavit.
third last page of the
Of
affidavit.
the affidavit.
Okay, this is the general conditions of contract.
This is WPC number 5255. I'm holding, but
Oh, I've got 533, 5335.
three similar cases.
Okay, so which one do you want? 5335 is the first one.
533.
Yeah, you have gone,
Yes, my mistake. I was
Yes.
holding the different read.
you have gone to the third floor without coming to the first.
Yes, herein at page 16, running letter page 6, running, I don't know. R4.
R4.
R4, page 16 in the affidavit, the running numbers I don't have.
Wait, I don't have R4 here. R5 is here. R5 is here. There's no R4 here. Wait, let me go to your 5255. No, you're saying?
Yes, Lordship, I was placing that.
Hmm.
5255,
Yes, page 27.
the third last page 27, R6.
This is 8/4/2021.
Exactly, Your Lordship.
Mhm.
This is the letter.
Yes.
Now, this is written by the corporation to the contractor regarding submission of final bill. Dear sir, this is reference to the above mentioned work order and correspondence towards settlement of the final bill of work order number. You are requested to submit the following documents: tax invoice, no due claims, PF, ESI, pending MTC. So all these documents are asked for. SD money against BC has already been released, receipt of which is confirmed by you over telephone. You are requested to visit the civil council office along with the above mentioned documents before to settle your claims and final bill. So these matters are yet to be settled.
So there's no dispute as on date.
There is dispute because they are asking for a particular amount in this petition. Their prayer
Oh, so this letter, is it applicable to all the writ petition?
in all the petitions, similar letters have been sent
Same,
because
same.
the same contractor is there.
I mean, the same requirement, the same
Yes,
documents are required. Then you follow this, you give them, what is there to
But
decide?
this was 2021. Now you're 2024.
Are the letters the same date in all the three writ petitions or? Let us see the 5335.
Yes, 8/4/21. Yes.
Wait, let me see.
Two matters I have seen 8/4/21.
8/4/20. Let me see. Okay, or for 2021, okay. And the other one, the last one, 5297.
97. 5297, this letter is not there, but there are emails. The various emails are there.
Ah,
Please consider this mail as a reminder for submitting necessary documents and signing a final bill. So this requirement is already there.
so this requirement is there,
In all the
also.
cases. In two cases, specific letters are there. In the last one, there's email correspondence.
Okay. But what is the work order in this last one in this 5297?
Construction of two-story electrical
Huh?
substation. Construction of two-story
The synopsis,
No, page, where is that? There has to be a work order number, so it becomes easy. I don't have to mention everything.
it is there, the synopsis. Lord.
Just enough to-
Synopsis, what you will see. Work order number is
Ah,
there.
that's enough.
Yes.
Okay. So we'll dispose it of in light of this, right? Heard Mr. K.C. Sharma, learned counsel for the petitioners. Acha, same petitioner active, learned counsel for the petitioner. For the petitioners.
No,
Petitioners.
there's one petitioner. Lord.
No, I have learned counsel for the petitioner in all the three writ petitions. Mr.
A Sharma.
A. Sharma appears for the
All the respondents
appears for all the respondent IOC.
IOCL.
IOCL. Uttam. The case of the petitioners in all the writ petitions is that he has not been paid his contractual bill in respect of three work orders issued to him till date. Uttam. On the other hand, Mr. Sharma submits. S.N. Sharma, no,
A Sharma.
A. Sharma, yeah, that's the father. Yes. Mr. A. Sharma submits that the
Settlement of final bill issue.
settlement of the final bill of the petitioner is still to be worked out after the petitioner submits documents as requested by the IOCL in terms of the letter dated 8/4/2021.
There may be some other letters also.
8/4/2021 and other letters which are mentioned in WPC 5335/2021 and WPC 5255/2020. Full stop. Next paragraph. The petition has been issued work order number 2478988 dated 20/06/2016. And number two, you write work order number 24841595 dated 16/8/2016. And work order number 24633870 dated 4/1/2016 by the respondent number two. Subsequent to the above work orders, the petitioner submitted his bills amounting to rupees 33,81,556.72. Then next will be comma. Then number two, 50,70,000. And 1,35,17,450.10. The respondent IOCM, on the other hand, had issued various letters asking for various documents from the petitioner for settlement of the final bill of the petition. One of the letters being REF DR/CVLT/30/2021/012 dated 8/4/2021, issued by the DGM civil, IOCM. This is at page 58 of the WPC 5255 of 2021. Okay, I put this. The said letter states the said letter which has been issued. Yes, no, the said letter has been issued in WPC 5335/2021 and 5255/2020. However, as the IOCL Council submits that the said letter will apply for all the three cases, the contents of the said letter and the contents of one of the said letters is being reproduced here as follows. Page 58 from red to red. Okay. Next paragraph. In the petitioners are accordingly directed to submit the document mentioned in the above letter dated 8/4/2021 to the
And thereafter, IOCL will take a call on this settlement.
to whom?
To the DGM civil,
To the DGM civil IOCL, who shall thereafter take a decision on the final bill payable to the petition. The said exercise should be concluded within a period of
6 weeks.
6 weeks from the date of receipt of a copy of this order. The writ petitions accordingly disposed.
Obliged.
Writ petitions are accordingly. So in the beginning, you write these three, the three writ petitions are being disposed of by this common order in view of the petitioner being the same in all the three writ petitions and the issue of payment of and the issue of non-payment of contractual bills being common in all the three writ.
Right. Huh? Oh, okay. Mr. A.C. Sharma, Senior Counsel, assisted by huh? P. Halda. Yes, any settlement?
Settlement from side, Malad, settlement has not arrived, my lord. But if your lord,
Is it going on or are you going to have it settled or what?
he had made a submission, but I have not received any instruction that whether or not there has been inspection.
That's what he had said earlier. He had said,
Yeah.
so there are talk for settlement is going on with the IPPTC authority. So, do you have any idea? Then you please instruct.
Well, otherwise, your lordship, my lord, if your lordship directly respondent number 3, to look into that grievance or the petitioner, then enter the
Mr. Counsel, you see, you've got to be very clear in what we are saying. If there is a settlement, if you are looking for a settlement and talks already going on, why should I poke my nose there? What is the requirement for this court to go into it?
My client, yes, that's what we try to settle that. But
Oh, your client wanted to settle, they don't want to settle. Right?
therefore, my lord,
It takes two parties to settle the issue. Mr.
Yes.
Ram. You
but
cannot do-
otherwise, my lord, in terms of the earlier interim order, my lord, we have already deposited 50% of the disputed amount.
Maybe, but then
Now the other part, my lord, for your
now
lord,
we have to take a decision on the main case.
here. Now, in that case, if your lordship will kindly see the ombudsman order. Says
No, Mr. Counsel, let us be very clear. You want to dispose of the matter, we can dispose it off. Or you want to try, you say that you want to attempt a settlement or what? What do you want? I don't want to hear and then you adjourn.
my lord,
If we are going to hear, we'll dispose it off.
I am praying for disposal, my lord, on the line that your lordship may direct on the basis of the materials, my lord. The lordship will direct the general manager of the Dibrugarh zone take a decision on this merit of the matter, my lord. The respondent free, my lord. General
No,
manager,
that means you're not asking me to dispose of the matter on merit.
on merit only, lordship will consider from this submission.
No, I'm going to dispose on merit, whether I should allow your writ petition or not, that's all.
But I am trying to make it more simple, my lord, by referring to the relevant material.
Okay,
That's why, my
that it should be heard by some other.
Yeah. Trying to make.
So what you're saying is that this writ court cannot decide the matter.
Yes, some technical aspect is here.
Correct, no.
So I
If he's agreeable, no doubt, no problem.
and that I am referring to page 74, 77,
Page 70,
77. Of the ombudsman judgment.
Yes.
Your lordship will kindly peruse paragraph number 4, my lord.
the justification.
Yes. The justification, may I read it?
Yes,
The justification given by the opposite party for not preparing the electricity bill in the month of March 2020 is not convincing. It is stated that high consumption detected in March 2020 could not be cross-checked by the concerned FME due to lockdown. But lockdown due to COVID-19 came into force with effect from 23/3/2020. And as per normal billing practice, the bill in March 2020 would have been prepared latest by 15/16 March 2020. Reading taken on 1/3/2020 for the purpose, if found high, would have been cross-checked by 15th of March 2020, and this would have facilitated central processing of the bill by APTCL in the next month of April 2020. That this was not done. So an inquiry was called for an inquiry. Now I don't know what inquiry happened. Now thereafter, my lord. Now from the above discussion,
it becomes clear that consumption of power did take place during the period contrary to the petitioner's case, the same being otherwise, and therefore the petitioner is liable to pay the bill amount so and so. The petitioner will clear the bill amount within 7 days of receipt of this order. Further, if any amount as per bill same subsequent or above bill is yet to be cleared by the petitioner, he will clear all pending bill amount within 15 days of receipt of this order. Now, pursuant to this, we have paid the 50% of the interim order, my lord, and the running bills we have paid. Now, your lordship, the last paragraph, at page 78. Page 78, my lord, of this judgment. From the data, subparagraph, from the data of monthly bill amount against the above consumer number of the petitioner from May 2017, it is seen that in certain months, monthly bill amount was above rupees 20,000. That was during the my lord, general period, not in COVID. And in several months, the bill amount ranged from rupees 12,000 to 18,000. Actual payment position as against the monthly bill amount in respect of the above consumer number of the petitioner for last 3 years may be verified from record, and this will be done by GM FPTCL Dibrugarh within 2 weeks from date of receipt of the order. Therefore, I am saying, your lordship, that your lordship will direct the GM FPTCL, consider the actual disputed amount of for the relevant period. That was not done in line of the order, man. Because your lordship has seen, my lord, page 77.
No, this bill is for which period?
This is for the period from 1st of February 2020 to 1st of April, sorry, 1st of May 2020, during the COVID-19 period. I mentioned in the synopsis, madam, from, I'm sorry, madam, 2nd February 2020 to 1/4/2020, that is one bill, my lord. And from 2/4/2020 to 1/5/2020. I was given only, my lord, provisional bill by saying, by remark that meter is not accessible. Then I came out with a case. Ombudsman was convinced that other 2 meter was installed in the same place, and it was not a case of non-accessible of meter. Now, if your lordship will kindly consider that page 77, relevant portion where I read it, my lord, and the last page 78, and it is PM FPTCL, my lord, takes a decision by going to the earlier previous bill amount. Because at that time my shop was closed due to COVID-19. There was a lockdown imposed and that shop was closed. That was, we have established it. And there is no problem. But the meter reader, my lord, he said that the meter was not accessible. But later on he says, my lord, that
What are you running in your place?
it was a restaurant, my lord. It was a restaurant in the net of eat, repeat. But that restaurant has got another 2 meters of in the same premise. Their 2 meter is accessible, but this meter they say not accessible. Then we wrote the report that these 3 meters are clubbed together, and then they came with a justification that due to COVID-19 meter reading cannot be seen. That observation is in page 77. That's now I have seen. That Ombudsman also said that this is for inquiry. There has to be an inquiry from why they have not done the metering during the relevant,
So Ombudsman didn't take any decision.
not taken. Like actual grievance has taken it.
He did not take it.
The grievance was not addressed.
Huh?
The grievance regarding the disputed bill amount was not addressed. Ombudsman called that an inquiry may be calling. That's why the lordship,
Ombudsman call it that an inquiry may be called for. But at the same time, this matter was disposed of. No inquiry was done thereafter. And at page 78, from the data of monthly bill amount against the above consumer, if I read my note, number of petitioner May from May. It is seen that in certain month bill amount was 20,000 and in several month bill ranged from 12,000. So what was the actual bill amount for the relevant period? Then they could not clearly establish. And no, my lord, final bill was submitted. Final bill was not given. Only before the ombudsman they came. So therefore, if all these things, if the general manager FPTCL considered, then your lordship may not hard entirely. Otherwise, I have to, my lord, place further on all the epithet and here we can statement and things like that.
If he agrees, if he does the three, there is no question.
Otherwise, the ombudsman has taken a decision. There is no pointed direction as such to consider his scheme, and that is not his, even his prayer, my lord. He's seeking setting aside of the order.
Yeah. So are we hearing the matter or what?
So if your lordship want to hear it, then if he wants to produce the record, then your lordship thinks that record is not
Here, madam.
Huh?
The pleadings and everything is here, it's part of the record.
no, your own original record of final bill and everything was not issued.
Bills are here.
Okay, right. On the further part is this the matter after 2 weeks.
Well, after 3 weeks, well, okay. I will be little out of station.
Okay, 3 weeks.
Well, the earlier interim order. Interim order.
If there is more to continue till the next.
Keep you. Obliged.
Made figure of.
Yes.
My lord, here in this matter, the petitioner was awarded a contract for construction of a bridge by the PWD department.
Where?
It was awarded, my lord. May I kindly come to, my lord, on 2/09/2019, my lord,
20919
2019.
and
And my lord, thereafter,
terminated.
my lord, in pursuant to an NIT, which was 26/05/2019.
Then
Then thereafter, my lord, he initiated the work first, my lord, by entering into an agreement between the PW department on 2/9/2019, my lord. Now, in brief, my lord, what happened? This particular contractor, when he was executing the work, my lord, he soon came, my lord, he was encountered with the advent of the COVID-19 and he could not complete the work within 120 days, which was the mandate, my lord, that he should have completed by 120 days. Then subsequently, he made some application and from time to time, they were extended to complete the time period. Even then, he could not complete it, my lord. And suddenly, my lord, by a legal notice served upon him by the council appearing for the respondent, my lord, they terminated the contract agreement. Now, this writ petition has been filed, my lord, primarily on the ground that the termination was made by a notice of the advocate. Advocate notice has terminated the work order, which could not have been issued, in pursuant to which, my lord, a formal communication was made to him, and no, my lord, opportunity of hearing was accorded to the petitioner before terminating. In just, my lord, that is the matter. If I may kindly take your lordship to the
No, Mr. Council, the first thing I want to know. Has the contract been completed?
No, my lord, it's not been completed.
Huh?
Contract has not been completed. Before completing the contract, it was terminated.
Yes, who is for the other side? What is the stage of the contract work?
So it was terminated.
That much I know, but then you have given to some other
Yes,
contractor.
yes, by,
So what is the stage of the contract work?
so it was,
As per the affidavit, my lord, they have-
You see, now the basic thing here is this. His contract work was terminated in 2021.
Wonderful.
Now it's 2024.
Okay.
Now whether the contract work has been completed by the
on,
third person or not.
on last occasion, I took a telephonic discussion that they have already processed, you know, and they were, work was not over. I can take the updated.
You think that because you see, we might be having listening to a matter which has got no relevance now. He might have to go for their damages for civil suit on this. So we'll have to see. Because that's 2024.
In affidavit, they have taken a stand, my lord, that new fresh tender they have initiated in respect of the remaining part of the work that was left behind by the petitioner due to the termination. At paragraph number 17, they have
How much work did you complete?
50%, more than 50%.
And then the NIT dated, new NIT?
And new NIT they have not issued. They have just stated that some amount has been sanctioned to proceed with the completion of the remaining part of the work.
Para 17, we said that the chief engineer has already approved. The work estimate has already been approved by the chief engineer for rupees 40.7772 lakhs. By communication dated 11/3/2022 with a direction to invite tenders from the. But
Tender has not been-
That affidavit is of which date?
it was filed in July 2023. July 23. At that point of time, it was not complete, but I can take the up to the question flow over telephone.
Otherwise, we can dispose it of, but then that will take some time.
But in fact,
But another thing, Mr. Counsel. This is a termination. Isn't there some arbitration clause?
Yes, but there are.
It is
arbitration
there.
clause.
That-
It is there. Now, we have a very limited term, my lord. What they did, they terminated my contract by an advocate. Can a question is, can by an advocate's notice my termination can be made, my lord? That is my simple prayer, my lord. So in any way, my lord, that has to go. Now the question remains now, will I be entitled for further completing the work or not? Your lordship will decide, because if my lord,
No, we don't, then they can decide,
yes, my lord,
not us.
the remaining part of the work, whether they are going to.
Whether they are going to terminate you afraid
Oh, yes, my lord.
or they are going to
Yes.
allow you to work. That. Yes, so you take a decision, you take factor as to whether his contract was terminated by way of advocate's notice. Or was there a termination in terms of the
Contract agreement.
the contract agreement?
But termination was the reasons are there.
Reasons may be there, my lord. I'm not
Mr. Counsel,
disputing on
that's not
reasons,
the
my lord.
True.
I'm
That's
not
not the
disputing
issue.
Let me.
The way it
I have
was,
not-
way
I
it
have
was
not completed
considered
my
terminated,
sentence.
I'm agreed by that.
I have not.
Let him.
I have not submitted the entire sentence. Look, the reasons are there and the reasons are apparent from the record. Why his contract was terminated. It is by an authority. I do it. That it advocate cannot. But the reasons are there and.
No, that is, I'm not on the reason.
But-
I'm just on the authority who terminated
Yes,
it.
that by advocate notice, he cannot.
He cannot.
It-
So the only
So
thing
the
is
chief
that,
secretary- So the.
so
chief
what does
secretary-
your affidavit say?
The reason why he was.
No, okay, so you have basically admitted that it was terminated by advocate's notice.
It is the very order. It is available.
Okay, let us see the implement.
Madam, at page,
Then we can dispose of the entire case.
Yes, the chief engineer is the authority. Ultimately, my lord, his demand
sir.
at page 107, madam, is the notice.
Yeah,
May I read, my lord?
yes.
Under the instructions of my client, namely so and so, my lord, executive engineer, I do hereby serve this legal notice upon you, stating the facts as follows. That previously 3 legal notices have been served upon you, dated such and such, respectively, in compliance with instructions of my above named client regarding completion of your work contract of STP breach from Rakhaldubi Anchalik Bazar to Rakhaldubi Sor. You have received the legal notices, but you did not respond the same. On the other hand, in your reply notice, you paid 45 days time to your engaged lawyer to complete the aforesaid work. But the stipulated 45 days of time is also over, so you are terminated from the said contract.
Okay, let us see the contract agreement.
On a contract agreement, your lordship will find from page 52 onwards, madam. At clause 4.1, it is the engineer who is page 54, madam.
Clause 4.1.
One, madam. Engineer's decision is there, madam. Except where otherwise specifically stated, engineer will decide contractual matters between the employer and the contractor in role of representing the employer, madam. So here the engineer
Where does it say about termination?
termination, my lord, may kindly come. 38 plus 52. Page 62, my lord. My lord, page 62, clause 59, my lord. 59.1 clause, page 62. Employer or the contractor may terminate the contract if the other party causes a fundamental breach of the contract. Fundamental breaches of contract include but shall not be limited to the following. My lord. Contractor must, these are the conditions. We have been faced with the difficulty due to the the pandemic that we have faced in 2 phases. So I could not complete that admitted political matter. So I paid for some extended time of 45 days. That was also not given to me. And
That's all.
So in fact, he was given time.
I
On many occasions, he was given, but he.
Time was the essence of the contract.
Yes.
No, no, I'm not on whether the reasons are germane or not. Only that the person who terminated the contract is not authorized to do it.
And subsequently, after this order of the learned advocate they formally intimated me by 8/10/2021 at page 108
Page 108.
Eight.
What?
The impugned order here because I cannot challenge the order of the advocate So this is the formal communication they have made. If your lordship may come to.
For 108, they've given you.
The communication they have given, but they have relied upon again the advocate notice here. At serial number 6 is the advocate notice, and in the first paragraph has been terminated by the advocate notice and closed. The last line. With reference to the subject, I would like to inform you that the work of construction, including a court road, has been terminated. Advocate notice included.
Okay, right. Heard, Mr. H. Burang Ohain,
My lord.
learned counsel for the petition. And Mr. D. Nath, learned standing counsel PWD bracket road for the respondents number 1 to. You see, this order of 2/3/22 is here. You take para 2, para 3, para 4, para 5, para 6, para 7, then next, right. The petitioner's counsel submits that the termination of the contract work had been done through an advocate's notice and not in terms of the and not in terms of the contract agreement executed between the parties. The communication made by the executive engineer, PWRD regarding the termination of the contract work was only a reiteration of the advocate's notice. He submits that as the advocate would not have terminated the contract executed between the petitioner and the PWRD, the impugned the impugned communication dated 8/10/2021 issued by the executive engineer should be satisfied. Next paragraph. Mr. Dinar, the learned counsel for the state respondent submit that the reasons for terminating the petitioner's contract was due to the petitioner's failure to dispose of, no, it was failure to complete the contract work within the stipulated time period,
Paragraph 8.
despite repeated extensions being given to him. He, however, admits, he, however, does not deny. Should I say that? Advocate notice, however, does not deny the fact that the termination of the contract work could not have been done by way of an advocate's notice, in terms of the contract agreement executed between the parties. That's all I think. I have heard the letter counsel for the no, I've heard the contract, I've heard the letter counsel for the parties. For clause 4.1 of the contract agreement executed between the parties provides that except where otherwise specifically stated, the engineer will decide contractual matters between the employer and the contractor in the role representing the employer. Clause 59.1 of the contract agreement provides that the employer or the contractor may terminate the contract, if the other party causes a fundamental breach of the contract. The definition of employer as given in the contract agreement states that the employer is the party who will employ the contractor to carry out the work. The contract agreement in question had been executed between the superintending engineer, public works department, roads, Western Assam Circle, Golpara, and the petitioner. The above provisions of the contract agreement clearly show that the advocate representing the PWD was not the employer of the petitioner, and as such could not have issued any letter terminating the contract being executed by the petitioner. Consequently, the the advocate's notice dated 27/9/2021 is it? No, advocate's notice dated 27/9/2021 cancelling the petitioner's contract work can have no force in law. In relation to termination of the in relation to the contract work being executed by the petitioner. Consequently, the no the no thus no thus comma, the subsequent order issued by the executive engineer. That is respondent number.
Executive engineer is respondent number 5.
Respondent number 5. Huh? Bracket. Respondent number 5. White letter dated 8/10/2021. Regarding termination of the petitioner's contract work. Is Huh?
Was call for measurement.
cannot be considered to be an order terminating the petitioner's contract work, as the initial order was without any as the initial order did not have as the initial order was not a valid order. Accordingly, the respondent number 5 letter dated 8/10/2021 is set aside.
So 810 letter by which he was directed to attend the site so that the work can be measured. It is also communication allowed to
Has terminated, has been terminated.
by way of termination. No, kindly see for the second paragraph. You are
Yeah.
requested to attend this office or send your authorized representative to be present at site to take up the measurement of the work executed by you within 3 days from the issue of this letter, failing which the department will not be responsible and the department will take
Correct.
steps for the measurement. It's a
Correct.
consequential action.
It's a consequential action to the initial thing.
That expert.
Pade distilleries, I think.
That expert measurement has been taken. And ultimately in paragraph 7.
No, only relating to the termination part. That measurement too you have done. That's
The
a different thing.
subsequent action has been taken already.
That is all right. That's all right. I'm only talking about the termination
Look.
because it cannot justify
Look.
the I'll clarify that.
Look.
What have I said? It's set aside, and as the same cannot be as the same cannot be constituted to be a justification of the petitioner's of the termination of the petitioner's contract work by the advocate's letter dated
27/09/2021.
27/9/2021. The petitioner should the state respondents are accordingly directed to consider whether to allow the petitioner to complete the contract work by way of giving him further extension. Full stop. Or comma. Okay, full stop. The above direction. No, the above direction is does not will not come in the way of the respondents
Taking a fresh
taking a fresh decision with respect to the contract work that had been given to the petition, that had been allotted to the petitioner pursuant to the NIT dated 26/5/2000. The petitions accordingly disposed of.
I'm highly obliged. Indeed.
Lordship, sometimes that, the, petitioner instructed me to withdraw the,
Let him withdraw.
Lordship, withdraw with, liberty. to
No,
press
where is the
my-
question of liberty? I'll tell you why. Because with liberty. Yes, what, Mr. Das? I leave it to you, Lord. Okay, Miss,
Actually, Lordship,
what is your name?
8 Cora.
Miss H. Borala, counsel for the petitioner. Says that she may be allowed to withdraw the petition, come out with liberty to file a claim. Mr. H. K. Das appears for the respondent number 2. Prayer of the petition's counsel is allowed. This petition is dismissed as withdrawn, come out with liberty as written. We have to have a meeting so far, Lordship, with the council for the, I've got to finish one that matter. No, that is now, I'm planning to finish it by this weekend.
Fine. Any assistance from me?
I am going to need
Yes.
from you and the other opposing
Yes,
council.
yes.
That's not answer. Not. Yes. Okay, right. Mr. P. Nayak, learned counsel for the PTC. Please for how much time? 3 weeks time to fill instruction. Accordingly, you to start after 2. 28, 20. What is your case?
Yes, my lord, regarding my lord, the settlement of an all matter 5 was accepted on 3 on my lord. ESI certificate not submitted, Pakistan certificate not submitted, and 40 digitally not signed. 40 digitally signed, I have an act.
Huh?
My lord, on 3 on my lord, my fee was rejected, my lord. ESI return not submitted, Pakistan certificate not submitted, and 40 digitally not signed.
What was not submitted?
Pakistan certificate not submitted. And the ESIC return not submitted, and parties my lord.
4 feet digitally not signed.
40
So?
digitally signed. For that page number 82 is
So, okay, so 4 feet signed. Then what about the registration certificate?
Pakistan certificate is not mandatory, madam. There is a judgment, madam. Vote on record, madam.
Okay, Mr. Please go good. Learned counsel for the petition is granted. How much time?
1 week.
A week's time to file affidavit in reply. Look them at after.
Highly obey.
Yes.
We have received
Can you give a copy to the letter to you? So when are you sending it to the finance department? Huh?
Because it's not in the pattern,
Not, who is not a party? Finance department not a party.
so I think it's
No, no. You take steps, madam. This order passed in 2019.
it's 100%. So immediately.
We'll list it again, we'll list it again.
Department.
Right. Miss, your name?
And Bora,
M. Bora, learned counsel for the
PNRD department.
PNAD department. Submit
or representing
that as per letter number E 459743 /7 dated 2/3/24 issued by the Under Secretary of the Government of Assam, PNRD. A proposal for sanction of rupees 2,28,914 has been made and is under process in the department for endorsing the proposal to the finance department for concurrence. Ms. N. Bora shall obtain the status report with regard to the above in the next, on the next date. This is the matter. After 2 weeks, after 3 weeks, 2 weeks, give a date, give a date.
That's it, 3 weeks.
Huh?
Yeah.
No. You hurry. Madam, the financial year is ending this month. You please get it done. You give it earlier than that, that's holiday time. This is the matter on 22nd.
That the matter relates to non-release of my lord contractual bill amount. Similar order has already been passed, my lord. Only the my lord amount and name of the work is different. Other sir. That is the direction passed in earlier order.
I say lordship, due to fund problem, we could not give. Otherwise, it was admitted. Due to fund crisis, also, it could not be paid.
Case 22 is the my lord live. Parties are same, my lord. Name of the work and amount.
What is, Mr. Roy, what have you said?
I said lordship, the liability is admitted due to paucity of fund, we could not pay. Could not pay.
Verified.
It is in particular, they have admitted due to the
What is the letter date?
Was-
Yeah. You make a photocopy. Give me the, you don't need it anymore.
lordship. Was admitted. I will do
Huh?
the photocopy.
What is the date in the particular? 15 February 2020. So you have admitted the amount of, who has admitted? Whose letter is issued by whom?
By the deputy commissioner.
By the DC. Then this order of the same thing. What is your name?
My lord, my name, my lord.
Yes,
Yes, same, my lord.
Ash Sharma.
Yes.
Ash Sharma. Who is for 1 to 5?
Correspondent number.
M. Deka,
Okay.
R. Deka. And Mr. S.S. Roy.
Respondent number 6.
Amount is
My lord,
99,990.
299,998.
so work will be different.
Yes, that lordship will find it in synopsis itself.
Synopsis, in the synopsis, the work will be different, huh? Okay. Work was completed when?
That is, my lord, in the 2019, my lord. 11/9/19.
11/9/19. Okay. A, huh? A, in para 6. He has also submitted a letter dated 15/2/24 issued by the Deputy Commissioner Sipsagar. Showing that he has admitted that the petitioner is liable to that the petitioner is to be paid rupees 2,99,99. The said letter dated 15/2/2024 is made a part of the record and marked as an extra. Then the same thing. So I put it there in. Okay.
Obliged.
Non-compensation order is 10/5/19. Applicable of my
Yes, Mr. Gogoi.
my lord, in November 23, my lord, the proposal has been submitted to the government by the civil engineer. And that, my lord, is awaited. Can it be after some time? My lord? That's the last one. We'll have time. Is awaited.
Okay.
After some.
Okay.
I have been filed for implement of,
Mr. Council, your implement, I think will have to change.
lordship, in the meantime, also lordship.
That, that be changed.
Yes, my. So I have to implement lordship. I
You have to
before that I
withdraw this,
Yes, lord.
this other IA. This IA civil, where is that? What is this? Item 34. You have not given me the IA. Right. Mr. R.K. Talukdar, learned counsel for the petition, submit that he would like to withdraw the IA
Yes, my.
and file a fresh IA, as the present IA has become ineffective. So, Mr. R. Dhar appears for the,
My lord, long back I was appearing for the respondent number 1.
okay, access for fund number. Chair of the petition, applicant's counsel is allowed. The IA is closed as ineffective.
Sometime lordship, my lord, this matter, my friend Dinad is appearing.
Huh?
My friend Dinad is appearing in this matter, my lord, I am told. He is on legs in another court. He will come after some time.
Non-compliance of order dated 27/9/2022. Annexure A, base 40%, page 160.
Yes, what is to be done here?
Lordship, I need for time to find my application, dear lordship.
Okay, Miss
Ah, that-
R. Deka appears for
all the respondents.
all the respondents and submit that he needs 4 weeks time to file affidavit in the police.
Lordship, one thing, your lordship, respondent number 2 has, transferred from his post.
He also submits that respondent number 2 is no longer holding the post,
New income.
for which a new incumbent would have to be. This is the matter of the 4 weeks.
Okay.
In the meantime, we make that application.
29.
Lordship, in this matter, you want to have the lordship is directed to say
Check for Dusty.
that the order phone number 4, but in the order it is reflected as phone number 2.
Oh,
Newly inflated.
okay. Who is here for whom?
I'm for response number 1.
Yes,
We are filing the Bharat.
okay. Right, right.
Okay,
Okay. Right. Mr.
K. Mira.
K.
Mira.
Huh?
Mira. MIR.
K. Mira. Also for the petition. Present. Mr.
A Bhattacharjee.
A. Bhattacharjee for the respondent number 1. Is present. Mr. U. Sharma for respondent number 2. Submit that affidavit will be filed within 24 weeks. He submits that Bakarat number will be filed today. Next paragraph. A typographical error occurred in the last order dated 19/2/2024 inasmuch as notice by way of justice service was supposed to be served upon the respondent number 4. Inadvertently, it has been written in the order in the last order that justice service should be made upon the respondent. The petitioner's counsel is allowed to serve justice notice. Is allowed to serve notice by way of justice service upon the respondent number 4. Like file affidavit of service thereof. Mr. U. Sharma submits that the respondent number 3 has been transferred out from the post that he was told. This is the matter after 4 weeks. Okay.
Lordship, in this matter, what happened, my lord, there is no formal work order. And pursuant to the instruction given by the higher officials of the service, I have lordship supplied the materials to them, my lord. They have admitted it. But as on date, your lordship, they have not cleared my amount. Amount is 42,66,552.
Lordship, I pray for.
Lordship,
Mr.
may I pray?
Mr. P. Chowdhury, left counsel appearing for the respondent number 1 to 4.
Lordship, 2, 3, 4.
2, 3, and 4. And Mr.
Hello, I'm private respondent number 8.
Yes.
Here in this, I mentioned the first item and paragraph 4 of I mentioned state program officer, officer. I am just a translator and just a translator to communicate. And of course,
These are the persons who have, I have personally named them because I have received
Okay.
email from them.
Huh?
I have received email from them to supply. They have emailed me pursuant to the instruction received from the higher authority. Let him be, let him remain, my lord.
I have had an IA for
It's not in record. How can
that wrongly met. I'm not sure my appointment was there. And it-
Anyway, it is. Counsel for the respondent number 3 to 4 submits praise for 2 weeks time to file affidavit in opposition. Praise the Lord. Mr. A.
And-
A. Nursery.
and I have
Learned counsel for the respondent number 8 submits that the respondent number 8 is not a officer, but only a translator.
language.
It has only a language translator. He accordingly submits that
I was thinking
further the respondent number
After
8
filing
has
the
already
petition.
resigned from the from the post of language translator under the ASSA mission.
Abhijan Mission.
ASSA.
before receiving the copy of the
How does it matter before, after, or how does it matter?
Let the IA be on record.
Let it come.
Lordship.
This is the matter of the truth.
Lordship, I'm told fund is available with the government, my lord.
What?
Fund is available.
Maybe, but we have to give us a file the affidavit.
Lordship, at ten.
Out here, there is no work order, nothing.
No, my lord, they've admitted.
Where is the
Yes, I don't
admission?
stop. Yes, they have communicated and whatever I have supplied, given for bonus of material. It's a,
Yes, why are you not paying?
Lordship, let me have the exact number. Have the exact number.
Give a date.
short date. Of like.
May I please? My lord, this I have been filed for correction.
Yes.
My lord, I was filed IA number 3552
Okay, right. Third, Mr.
M. Hussain Bhai.
M. Hussain, learned counsel for the petition applicant who submits that a typographical error occurred in the order dated 13/12/2023, passed in IA Civil 3552/2020, combined as much as the applicant therein was
Gauranga.
Sri Gauranga Das. Correct?
Yes.
However, in the said order dated 13/12/2023, the applicant's name is shown to be Shri Charan Ray,
Gauranga.
who is actually the writ petition.
My lord, address also address wrong limit.
Pushtam.
Name
The name and address. Ah, no. He submits that the address of the address shown in the order dated 13/12/2023 also pertains to Sri Charan Ray and not to Gauranga Das. He accordingly says for correction and modification of the order dated 13/12/2023. Next, Mr.
BC Deka.
BC
Deka.
Deka, learned counsel for the
Opposite party number one repeat.
writ petition and
Opposite
Mr.
party number one.
How does it matter? And Mr. S.S. Roy, learned counsel for the respondents number 4 and 5, submit that they've got no objection to the application being allowed. On considering the fact that there has been a typographical error in the order dated 13/12/2023, the same is modified and corrected to the extent that the applicant's name is actually Mr. Gauranga Das. Gauranga
Das.
Das. So accordingly, Mr. Gauranga Das is implemented as the respondent number 5. In the writ petition.
In the, my lord, in the,
Huh?
on the basis of this order, my lord, in the writ petition also wrongly typed, my lord.
So consequently, the
Page number 10, my
consequently the consequently the impugned order consequently the order dated 30/12/23 passed in WPC 6143 of 2023 can also be modified to the extent that the person who has been allowed to be impeded as point number 5 shall be Shri Gauranga Das, address center. Then the petitioner takes steps for service of, and then no, that's all. Then you write petitioner to submit the corrected cause title in the writ petition. Then you write in the main case, you write in view of the order dated 4/3/2024, passed in IA Civil 679/2024. Shri Gauranga Das, Mr. Sensu, in imperial point number 5. By recalling the earlier order dated 13/12/2023. Oh, no, why recalling, huh? That's. Good. Then who is appearing for respondent number 5? Notice will have to go. Issue notice to the respondent number 5, Gauranga.
My lord, I am for
Oh, sorry, sir. You have to file affidavit deposition.
Yes.
Mr. The respondent number 5, Sri Gauranga shall file affidavit deposition within
1 week.
within 1 week. This is the matter after 2 weeks. And in that, IA, of course, shall dispose of. Huh?
Most obliged.
Anyone, production list of the case. I don't know, Mr. B over there. What are your instructions?
The item of the 32, contract. 33. I have given a copy of the proposal to you. As regards the status in the government. Monday or Wednesday?
On Monday, Wednesday,
Wednesday.
next week.
Next week.
On the fair of Mr. B over, list the matter on Wednesday.
13.
Pending item 35 and 36.
Complaint filed for non-compliant
Who is that? No, again, Mr. D Nath is supposed to pay. He's not here. Next.
Well, regarding one order whereby my lord 5 borewells of the Assam Cricket Association have been directed to be sealed, page 95.
Huh?
Page 95, annexure T. My lord, for not having the NOC from the Central Groundwater Authority. My lord, this, we are unaware of this, my lord. For the first time, we came to know about this particular NOC. On my lord, 8/6/2023, page.
Oh, no, just a minute. Page 95 is the order, huh?
Yes, my lord. Lord, you will see that date down below. It is fixed on 6/3/24,
Where?
page 95.
Ah,
my lord.
60.
Yes.
Which refers as down to form the affidavit, the following page 60.
My lord, on 13/2, we have already applied before the authority
For what?
for this NOC. Now, after that, they have issued this, my lord, order, it's been ordered. Whereby
Where is that
page
13/2?
750, by paying a, my lord, amount of rupees 1,54,000 as per their demand. Annexure N, page 73.
Yeah.
Lord, you will see your application submitted successfully. So and so,
You have applied for what? For
for NOC.
NOC for installing a borewell.
No, for my lord, running the borewell for expecting groundwater.
For
Now, my
running
lord,
the,
it is for
so there is a
groundwater-
borewell.
Yes.
So you have asked for utilizing the borewell.
There are certain norms, my lord, we have to be fulfilled up.
So they have not given you any decision.
No, my lord, from 13/2, my lord, we have applied, successfully applied, he is lying with them. Now suddenly, my lord, this particular order has been passed on 6 weeks after 1. So it's up to them to expedite, my lord, to give the NOC.
Okay, right. I heard Mr. B over, then counsel for the petitioner. To submit that the petitioner had applied for extraction of groundwater to 5 borewells installed in which stadium?
My lord, it is the Batsapara ECA Cricket Stadium, my lord. It is the campus of-
Write it down. Okay. In this respect, the petitioner had made an application on 13/2/2024.
before
However,
respondent-
to the
before
respondent number
respondent
2. However, however, instead of taking any decision on the petitioner's application, comma, the impugned letter dated 26/2/2024 has been issued by the respondent number
My lord, it is respondent number 6,
6,
5.
5,
Try to look.
stating that as per the direction received from the additional district magistrate. District magistrate where? Guwahati?
Yes, sir.
Guwahati, comma. The borewell are to be sealed on 6/3/2024. We issue notice or what?
Notice, sir.
Issue notice returnable in 3 weeks. Mr. S. is Roy accepts notice on behalf of.
It will be all. My lord. And if you put a central also, my friend will take for the stapler. I'm for 1 and 2.
Accept notice on behalf of respondent number 1 and 2.
1 and 2.
While Mr. D. Nath accepts notice on behalf of respondent number
4 and.
Huh?
You will for my lord 1, 2 and 3.
1, 2 and 3. For 4 and 5. This is the next returnable date coming. The letter date is 26 to 2024 issued by the respondent number 5. Can be kept in a bay.
Highly obliged.
35, 26.
The customer filed for non-compliance order dated 22/4/2021. Owing the action of began because respondents to release the security deposit from during the when the notice was issued to the container, they filed a review.
But the item number 36 is the review.
Attempt the
36, kindly take up item.
local kindly have to look the order of the
Now, one at a time, Mr. Anand, you are saying only one. Give each other some time. Either one of you are. Yes. Yes, Mr. Nath.
Look, we have filed this review petition for enacted the order that you will find at page 15. This direction is to release the security report.
Just a minute, page 19.
Page 19, it starts
Page 19 is a review petition.
of the review petition. Order dated 22/4/2021. Sir. The this grievance is not release of the security deposit of the 13. Finally, Lordship will find the direction of the honorable court is page 20. Page 20. MS M. Pukon in terms of the state order dated 9/3/21 has received necessary instructions from the Joint Secretary to the Government of Assam Fishery Department by letter dated 19/4/21.
Just a minute, 1 minute. The
Sorry.
director of fisheries
I'm reading the last one.
Jitin Kalita. Completion. So there are 2 fish farms.
Logic, there are 4 in fact. As regard the security deposit of 3 contractors come with petitioners in the linked cases mentioned above against their names, MS Brahmaputra Associates, Satguru Engineers, and Ajay Jalan. It is submitted that in view of the report of the technical cell of the Director of Fisheries, government respondent has no objection to release the security and any other such deposit held under objection now. In view of the stand taken by the respondent number 1, as consented by MS Bukan, this petition stands disposed of. Under that, no objection was in respect of those 3. In respect of this petitioner, there no objection was not there. But we have annexed the inquiry report in the review.
What has happened? No. So there was an upgradation of fish farm.
Lot.
Then he was settled with one of the contract work.
Contract work was given to the petitioner.
And the other 3 persons.
Along with other 3. But there was some misappropriation of money. That is why inquiry was there. And after the inquiry, the authority came to the finding that in respect of the other 3, we have no objection, we want them to release. But in respect of the petitioner, I'll take your lordship to the inquiry report we have annexed.
So
Those inquiry reports were not placed before your lordship at the time of disposal. Considering no objection in respect of others, this petition has been disposed of and directing the government to release the security deposit in respect of the petition. So the last paragraph, page 21 says that the petition stands disposed of hereby directing the respondent of board, the Director of Fisheries, to release the security.
and who is the petitioner here? Who is he?
He is the contractor.
I'm the contact.
Who is what's your name?
My name is
Jitin Kalita.
He is Jitin.
So he is the one to whom there was no objection certificate was not given.
No, we have objection. In fact, in the report, I have.
No,
annexed.
so this court order.
Not.
This amount claimed by the petition shall be verified and released.
Okay, prior to that,
What a color. Just a minute. Okay, what a color. Just a
Well,
minute.
But the honorable court has said that thereby directing the respondent number 4 the writ petition stands disposed of, thereby directing the respondent number 4, the director of fisheries to release the security deposit of the petitioner amounting to rupees 13,22,006 as against the work referred herein above in respect of upgradation of JP or fish farm Raha in the district of Nogam under RIDF 19. The amount claimed by the petitioner shall be verified by the respondent number 4 and release the same within a period of 60 days from the date of receipt of it. So this is the direction, my lord. In fact, my lord, when the matter was taken up, before that, my lord, there was a report, my lord. That particular report was not placed before your lordship at the time of disposal of it. Although the instruction was placed, kindly see, my lord,
No,
next-
why did the court say this when there's no objection?
in fact, my lord, the 19th letter which the honorable court has referred.
Just a minute.
Meeting paragraph.
Just a minute.
Look.
After there was nothing stated against the petition.
Okay, that's okay. No, I'll just apply, my lord. Kindly similar the paragraph which I have read. The instruction is my lord, at page 20, logic has referred that the MS coupon in terms of the order dated 9/3/21 has received the necessary instruction from the joint secretary, by letter dated 19/4/2021. This letter, my lord, we have annexed that logic. We'll find at page 12, so page 14, my lord, annexure 2. This is the letter, my lord. This is dated 19/4/2020. This was placed before logic, sir, on that date. And my lord, the annex, kindly see, my lord, this letter contains the draft, the detailed report to conclude that. The report kindly, my lord, come to page 17. The part of the report, sir.
Yeah.
Based on the above, the director of fisheries Assam has already been directed to take immediate steps for recovery of the excess amount by letter number so and so dated 8 April 2021 from deducting from the defaulting contractor Sri Jiten Kolita writ petitioner in WPC number 7813 of 2018 in the light of the observations, direction of the principal accountant general Audit Assam. Right later on the reference without any prejudice to the pending writ petition relating to release of security deposit of the state defaulting contractor Jiten Kolita. As regards the security deposit of other 3 contractors from writ petitioner in linked cases mentioned above against their names, MS Brahmaputra Associates, MS Sadguru Engineers and Allied Services Private Limited, and Ajay Jalan. It is submitted that in view of the report of technical cell of the Director of Fisheries, government respondent has no objection to release this security and the other such deposit held under objection now. So this is the report, my lord. It was there, but it was inappropriately not pointed out before.
With regard to the first paragraph.
With regard to the first paragraph, Lordship has quoted the second paragraph that in respect of 3 there is no objection, but in respect of Jiten Kolita there is objection because the report is against it. And in fact, the AG
So
report,
what is to be done now?
my lord, we have prayed for review of the matter, my lord, so that the direction of the honorable court is very clear. The Lordship has disposed of the writ petition, directed the respondent number 4 directed to release the security deposit of petitioner amounted to 13,20,000. So that's one of the, because the inquiry report has come and if there is illegality found, the authority has to do as per the terms of the country. So I would say one of the order may be reviewed and the writ petition may be referred so that we can take it to it.
Yes. Okay,
The AC report also we have annexed that page there, annexed of
High order is 116 work order has been allocated to the authority completed work. When the work was going on, then the top officials of the department examine the etiquette problem. After that, the bill has been released, but 8% security has been keep in their custody. After that, we filed application for release of the security money loss. At the time of release of the security money, the authority informed that one complaint has been received
from one RTI activity. When we notice was issued lottery one state, then this court directed the government council to produce the debt complaint, which was filed one RTI activity, namely Gulal Goya lawsuit. But in the disposal of the litigation lawsuit, they have not submitted debt complaint lawsuit. And during the pendency of the litigation lawsuit, the FISHERY department conducted inquiry for the applicability of the government lawsuit. That is the engineering department, irrigation department, government of Assam. The report was in the order lawsuit, that is page 20 lawsuit in the review petition. The honorable court already examined that aspect of. And have a look, if we consider the report of superintending engineer.
Where, which page?
Page 20 of the review.
Yes.
The order which was disposed of by the honorable court.
Yes, yes, yes.
If we consider the report of superintending engineer irrigation, one fact is clear that there was some work carried out by the petitioner and other contractors. From the instruction, it is also clear that one of the officials of the FISHERY department was suspended on the ground of the misoccupation of funds with access for rupees 2 crores. And the departmental proceeding was initiated against him. The petitioner has a right to know as regards to dispersal of the contractual bill, and though the respondent department initiated inquiries one after another, there are no materials to show any imputation against the second petitioner. In view of the same, let this matter be listed after 4 weeks. Mr. M.S. Fukan shall take necessary instruction in respect of the follow-up action by the respondent in view of the disagreement by the chief engineer for reputation of an additional chief engineer, else referred herein above. But already they have examined, one after another inquiry has been conducted. No allegation has been made. They have found us. So clearly stated by the court.
This document at page 17. What is the date?
But this was forwarded, page 14 is the order. Page 14 is the letter, 19/4/2021.
Hmm?
19/4 and page 14.
Okay,
This is the forwarding letter.
19/4/2021.
And this has been taken note of by the honorable court.
Letter already.
Yes, sir, it was placed on that day before your order. And my learned friend has read that part. This is the part of the honorable court order. It is order dated 9/3/2021. On that day, after this observation, the honorable court has directed the learned government council to take further instruction. And after that, my lord, by letter dated 19/4/2021, the instruction was taken. And this is the instruction at page 40. But the status report reveals that there is objection as regards the petitioner.
This is 9/3/2021, this is 19/4. So this order, that page 20 you are reading, is of March,
19/2020.
Yes,
and is March. And this order, this other one, the report, is subsequent to that.
19/4, their report of, honorable court produced their report. After that, the honorable court passed this order on 22/4/2021. The order was passed on 22/4/2021. Committee action
on
it was
9/3/2021.
passed by the learned council on that time. The order dated 19/4/2021.
Yes.
Then, my lord, the Swatantha Kumar is already examined.
Just a minute, yeah.
Well, on 9/3/2021, the honorable court has observed the disagreement between the chief engineer and for deputation as additional chief engineer, there was some dispute, and therefore directed the learned government council to take instruction what they have done further. And on that day, this 19/4/2021 letter, along with this letter report was placed before. And my lord, and inadvertently, that particular objection of the government was not pointed out.
Not, that first paragraph was not made.
Yes, it was not. It was clear to us, and ultimately the direction was. Now my friend is arguing on merit. We are ready not at all. That is allowed to be the petition will.
The work is completed in the year 2015. There is no dispute, the work is completed. And they make an inquiry on the basis of the RTI activity application. But their application, the allegation not that their my lord, before my lord. So there is a judicial order. Lord. I have annexed in my reply. Lord. In the review system, in my affidavit in opposition, there is a reply. Lord.
On 24/2020, there is an order.
So
What
the-
is the complaint?
Okay, right. Heard Mr. NJ Governor counsel for the, no, heard Mr. Dinath, learned counsel for the review petition. And Mr. NJ Governor, learned counsel for the writ petition. This application, this petition for review. I'm for it. You're the respondent, but you're also the writ petitioner. Then? What have I said? For the writ petition. For the writ petitioner, this petition for review of the order dated 22/4/2021 has been made by the review petitioner on the ground that where is that writ petition? It's not here.
writ petition, matlab,
Where is the prayer made? Is that writ petition there? What is that? Seven, eight, one, three. What has happened to the other two writ petitions?
Other cases are disposed of, because there was no. In fact, in that line, this order was also. There are four.
This will be the prayer. What have I said? On the ground that the direction passed by this court to release the security deposit of rupees 13,22,006 to the petitioner for the contract work of upgradation of JB Ghar Fish Farm, JRH, Ghar Fish Farm, Raha, Nagaon district, under RIDF dash Roman 19. Made by order dated, made by the impugned order dated 22/04/2021. Have inadvertently not taken into consideration the
We have taken the ground at ground C, phase 7 of the division.
not taken into consideration the sixth, the fifth last paragraph. The fifth last paragraph of the status report on inquiry against the alleged misappropriation of government funds under RIDF Roman 19, which was forwarded by letter dated 19/4/2021, issued by the Joint Secretary to the Government of Assam, Fishery Department. The petitioner's counsel, the review petitioner's counsel submit that in the impugned order dated 22/4/2021, this court had directed the release of the security deposit of rupees 13,22,006 to the petitioner only by considering the fourth last paragraph of the status report on inquiry against alleged misappropriation of government funds under RIDF Roman 19, and by inadvertently not considering the last fifth para of the said report. But why don't you go to in appeal?
Look, effect, the last, it was,
How do you know that, you see,
it is an,
why should it be a review?
it is an inadvertent, mistake on the part.
How do you know?
But since the report is very clear, that objection is there, but it does not.
So stop. He submits that in terms of the fifth last paragraph of the report. So there was no occasion for the learned for this court to have allowed release of the security deposit to the petition, to the writ petition. Next, Mr. N.J. Gogoi, the learned counsel for the writ petitioner. On the other hand, submits, what do you submit?
Have to already examine that the line, but the petitioner has a right to know that because the reversal of the contractual bid and though the respondent department initiated inquiries one after another, there are no materials to prove any against the petitioner. There is no materials against the petitioner law. And as the good deputy governor speak after releasing the bill law, at the time of the lawsuit, the work of the higher officials of the department examine the work site. They visited the work site. In my additional affidavit in the writ petition, I have annexed that with analysis. In the report they said, for 19.4, they have in the first paragraph it said that one complaint has been received lodged by Dulal Boy, IT activity. There is a judicial order of the honorable court to produce that complaint. That was not yet produced. The order dated 24/12/2020. There is the order in
Look, this is misappropriation. Where is the liability of this person? This writ petitioner.
Just look at it comes to page 16. Just in the.
Yes.
Now, the principal accountant general audit, Assam, in his report also found anomalies with glaring mismatch of measurement of work in the inquiry and report of the superintending engineer monitoring irrigation department, who was engaged by the chief engineer irrigation on request in the intervening period shown below. Consequently, the principal accountant general Assam, in its draft paragraph, directed that the excess amount of rupees 44.39 lakhs to be recovered and also fixed responsibility on the officials who had recorded the measurement book and also submitted incorrect report. Now, in view of the latest development, Director of Fishery was requested to submit a factual report on the matter in the light of the report findings of the Accountant General Audit Assam. It appears from the report that a technical cell of the Directorate write letter number 3/4/2021 that the said work was allotted to only one contractor, namely Jiten Kolita, out of 4 contractors engaged for execution of the whole project. So it was the petitioner on the writ petition. From the report of the technical cell, it appears that the said contractor Jiten Kolita was paid total amount of rupees 1 crore 80 lakhs and 52,550 for the works as per two work allotment order dated 1/1/15 for Group A and Group B works, including 78 lakhs 9,171.50 against three sub-estimates held under objection by AG Assam for excess payment of 44.39 lakhs. The Director of Fishery has already adjusted security deposit of 13,22,600. So this is the amount for Group A and Group B against the contractor from the excess amount of rupees 44.39 lakhs, and further held up the EMD for Group A and Group B work for rupees 3 lakhs 75,165. Thus, the balance amount of rupees 27 lakh 41,898.29 is now to be recovered from him, from the petitioner. It is further seen that the report of the technical cell that the other three contractors who have filed cases before the honorable court by WPC number 7783 of 18, Promote to Associates, 7807 of 2018, Sadhguru
Okay, right.
Engineers.
What about it?
It is very clear.
On the other hand, submit that in terms of the order dated 9/3/2022 and passed by this court. Some work were carried out by the petitioners and other contractors. Further, there were no materials to show any imputation against the petitioner. Accordingly, submit that no case of review has been taken.
The completion certificate is issued by the director.
Huh?
The completion certificate of work.
I have heard the for the purpose. In the impugned order dated 22/4/2021, this court has allowed the release of the security deposit to the other three, to three other persons on the ground that the report of the government has not found their involvement in the misappropriation of money. However, in respect of the petition hearing, in respect of the writ petition hearing, what is this, in view of the stand taken by the respondent, what stand did the respondent number one take?
In fact,
Page 20, the last line.
in fact, the stand of the respondent is 19/4/2021.
Correct.
That is clear.
The-
It has not been placed.
Mr. However, in respect of the petition number one, direction to release the security deposit of the petitioner amounting to rupees 13,22,006 have been made. In view of the stand taken by the respondent number one, that is the state of affairs. However, next paragraph. However, on perusing the status report of inquiry against alleged misappropriation of government fund under RIDF 19, right, which is annexed to the letter dated, which is annexed to the letter dated 19/4/2021, issued by the Joint Secretary to the Government of Assam from a Fishery Department.
It was made a part of the record.
It has been clearly stated that necessary steps for recovery of excess payment made to the petitioner should be made. It appears that the, that in the, that is, it appears that in the impugned order dated 22/4/2021, the next para. Money to the petitioner has been made only due to a has been made, no, not due to, has been made without noticing the fact that the respondent number one's report is not in favor of the petition.
So you're unable to record the, let us keep a record of those report. Huh? The report 19/4/21 not being record. Just keep a record when the order was passed. Just schedule those. Just schedule.
The order reflects.
It is requested a certain obtained by MS Coupon. I letter say 19/4/21 from the joint secretary.
In the, in view of the reinstatement of comma,
Order 47.
in view of the, what about that? In view of the fact that a mistake, that error has occurred, which is apparent by looking into the impugned order and the, in conjunction with the report made by the state government. The review petition should be allowed. Accordingly, the impugned order dated 22/4/2021, passed in 7816/2018 is hereby recalled. The review petition is allowed. Is hereby recalled and the writ petition is restored to file. The review petition is allowed. Then you write in the main writ petition. No, you write there. A registry to list the writ petition after 3 weeks.
Follow the item 30.
Then in the what time please will go.
In view of the.
That's right.
document proof.
Next para. Heard Mr. N.J. Gogoi and Mr. Saha. In view of the order dated 4/3/2024, passed in review petition number 107 of 2021. Now, the review petition, the contempt petition is closed.
In the contract, they file a review after filing. This is the contract notice.
How does it matter?
They are silent from 2020 or something. After receiving of the notice. That is any record.
I am basically on the merit of that thing. There's been a slight error. We'll see. I